All right, we should be good to go now. Mute that. Okay, Ms. Rivers, are you ready?
Yes, Judge, I'm ready.
All right, this is the revocation proceedings against Mario Copeland. Mr. Copeland is in court. He has 2 open cases for which he is on probation. He has an unindicted case. And then we learned that one of his cases is closed out. It has expired, but 15 SC 135142 and 15 SC 132454 are still open. 2 years and a few days left on the case ending in 454 and a year and 10 months remaining in the case ending in 142. Mrs. Collier, if you could get us started by getting on the record what the allegations are in the warrant or the petition as to why Mr. Copeland's probation should be revoked.
Yes, Your Honor. Your Honor, the defendant, according to the warrant, he violated condition number 6, do not change your present place of abode. Condition number 8, participate in and successfully complete rehabilitative programming. Special condition, enter and complete drug court. The defendant was placed into the Serenity House on 12/14/2022. The defendant did not return to the Serenity House on 12/15/2022 and was considered AWOL from the drug court program. On February the 28th, 2022, the defendant was terminated from the drug court program. Your Honor, according to the probation officer, Lindsay, she stated that this defendant has approximately 18 prior felony convictions. Your Honor, it is the defendant's issue that brought him into our drug court program, consisting of 4 separate cases. And Your Honor, it is our belief that the defendant still possessed the issue that brought him into the program, which is the severe addiction to drugs and or alcohol. And for that reason, we're asking that the balance of probation is revoked. And if he qualifies for RSAT, that he complete the RSAT program. Thank you, Judge.
Thank you. Ms. Hankins, what do you want to tell me about Mr. Copeland and his hopes as to how this gets resolved?
Well, Judge, as we discussed at his termination hearing, he did want to stay in the program, and he wanted to stick it out. He didn't cut monitor off, and so we are now facing the revocation. He does still want treatment, Judge, and Mr. Patterson has arranged for PAD for him. We are asking the court to revoke 90 days, give him credit for the time served, and order him to PAD for 6 months, or as what term the court deems necessary.
Okay. Mr. Copeland, my calendar says you've been in for about 50 days, 50, but it was published a little while ago. You've been in for about 2 months?
Yes, sir.
Okay.
So, and 2 months and a week.
2 months and a week.
Yes, sir.
Okay. And give me your best explanation as to why drug court didn't work out for you, because you're asking for a different form of treatment by going through PAD. I need to understand why you think PAD would have a different outcome than drug court.
Be honest with you, I think I explained you last time. You might not remember that. I was kind of like weighing my own options when I went to drug court. I mean, I knew that I would be able to do it, but being in a drug-related area that I was staying in, that kind of limited me from doing all the right things that I needed to do. So the last time I was here, I was kind of completely honest with you about about an inpatient program. So yesterday, a guy from PAD, last time I was here, you said that drug court was gonna find another program. So, yesterday, PAD came to, a guy from PAD came to see me, he explained to me some of the conditions and, outlooks of that program. So I kind of like, you know what I'm saying, was, curious and optimistic about wanting to see what was going on there. But, whatever will of the court is, my favorite the court is, it is what it is, sir. I mean,
Okay.
I have no excuse.
Well, I appreciate you saying it's not an excuse. You have an explanation, which is you're struggling with addiction. So this isn't Mario Copeland out there beating people up. It's you're having trouble taking care of yourself. The Marcus Collins, that's just an alias. I want to make, okay, same initials, just different guy. Okay, all right. Mr. Copeland, my thought is to get these two cases off your back. You've got a new case. You have an open, unindicted shoplifting case that is still out there. I appreciate your interest in wanting to try another program. I saw how this one ended. I see the criminal history that you've got, and I'm hoping you, as best you can, age out of some of this, that you just get tired of where some of these decisions end you up. But I also get it that it's not always a conscious decision you're making. If you're in the wrong place with the wrong folks, you just sort of get swept up in that. I'm going to revoke 1 year on both your cases and close out both your cases. So when you're done with the revocation, you'll get credit for all the time you served. You'll be done with 15 SC 135142 and 15 SC 132454. It's my hope that the district attorney's office, considering the length of this revocation, will either expedite getting you accused in the CP case or otherwise handle it so that that's not something that follows you along. Mrs. Collier, do you have a sense of where, I know you don't control the CP cases, do you have a sense of where this one is going?
Your Honor, I am not aware of the status of the case, but I can find out as soon as I get off of this call.
Okay. All right. Ms. Tucson, do you need any other information? Ms. Tucson. Well, if we learn that she needs more information, I don't know. Ms. Nelson, can you try to get in touch with Ms. Tucson? I'm going to need her plugged in throughout this calendar. Thank you. Mr. Copeland, I'm going to have you stay right there because I need probation to let me know they've got everything they need. So sit tight. I'm going to start calling the trial calendar so we can get that process underway, and we'll let folks move around in a minute. So our trial calendar, we're calling today. I know there are some cases that are resolving today. I'm happy to take pleas. I can be here until late. Jury selection occurs here in this courtroom Monday morning. And so what will flow from today is an email that some of the lawyers will get from me that lists the cases in the order in which I think we'll call them out on Monday, those that weren't resolved today. And a resolution could mean, it's not my favorite resolution, that it's continued. But if you're told today that it's continued, you don't need to worry about being on that email that will list the handful of cases that need to be ready to go with jury selection on Monday. The goal is not to be taking a lot of pleas on Monday. It's to be picking a jury. So if the case is working out, it ought to work out today. But of course, a client can always change his or her mind. And when they know a jury is coming, they could decide that they're going to take a plea. And that could be what happens on Monday. Our first position is Heavenly Mitchell. Ms. Willingham, is the state ready on that case?
Ready.
Okay, Ms. Feely?
We would be ready, however, I relayed an offer to Mr. Mitchell that he was thinking over, and I think we're very close to it.
Okay, something that we should keep open today, as in you're going to talk with him today.
Bring him Lamar Jackson, you're going to pay him just as much, maybe a little more than
What are we hearing from Ms. Tucson?
She's on the phone.
Ms. Tucson, are you there? All right, we cannot hear you, Ms. Tucson. And Mrs. Collier, you are free to go. Thank you. All right, so Heavenly Mitchell is ready. Possible plea. Position 2 is John Connor. Mr. Shapiro?
Good afternoon, Judge. We can be ready when reached. However, I believe we're close to a negotiated resolution in that case.
And he's here. Okay, so similar to Mr. Mitchell. All right. Ms. Grant. There she is. Hey, Ms. Grant.
Ready when reached.
Okay. Ms. Grant, if, and I promise to give you some clarity on it, but if we are going to do your trial on Monday, you've got care for your child? Is it your dad again?
He had to retire, he retired next week, but my brother stayed in Midtown, they said he'll do it.
Okay, someone though, you won't need to bring your child here. Got it. Okay. Ms. Feely, anything on Ms. Grant that we need to know about? Okay, fantastic. Mr. Muckle. I think I saw Mr. Hoover. Hey, Mr. Hoover, how are you?
Hello, Judge, how are you?
Honored to have you in court. Mr. Hoover, you have filed some important evidentiary motions, in particular the Daubert on the geofence. And I'm not able to hear those between now and Monday, but we need to set those down. So my thought is that we need to calendar at least the Daubert. I know you filed something today, but I skimmed it. I agree with you that that's probably one that's a motion in limine that we could sort out while we're waiting for the jurors. So I think what I'm going to do is have Ms. Nelson work with your schedule, given that you are pulled in lots of directions, to get a few dates that would work for you on when we could have the Daubert hearing. And obviously, Mr. Abate, wherever he went, there he is. He'd need to be available as well, and he'd need to bring some witnesses in. But that's something that's not a 5-minute thing. I'd need to receive evidence from the state. And so my thought is that we can't go forward with Mr. Muckle, given that pending motion.
Well, okay.
But I'm open. I mean, you could say, you know what, if I'll withdraw the motion, or I'm not asking you to withdraw anything. But I can't. A Daubert motion isn't one that I just rule on the pleadings.
I was actually going to say the opposite. We have the Daubert motion, we have a 404B history or prior history motion.
Oh,
It's probably going to take some time as well.
okay.
4 different priors the state's trying to bring it.
Okay.
So we're going to need.
You're agreeing that we need a minute to hear argument on effectively evidentiary motions so that everyone knows the landscape before trial. It may not cause something to plead out, but at least you'd know these other acts are coming in or they aren't. The state would know no geofence or yes geofence, all of which both sides are entitled to know to meaningfully prepare for what the trial would be like. Okay. All right. I'm happy to deliver that news to Mr. Muckle. If he was thinking Monday is my trial day and there's light at the end of the tunnel, I'm happy to bring him to the door. You tell me what you'd prefer.
I'll sit down and talk.
Okay. I will have Ms. Nelson. I need to look at all the motions. I hadn't remembered the 404B.
Fairly recent. I apologize.
Okay. But now it's not late. So
There's only 4 issues: the geofence, the 404B, the victims that we can do right before trial,
Yep.
and the suppression of certain evidence. But
Yeah.
it shouldn't take long.
okay. But it sounds like we might need to block out a morning or an afternoon, and that means finding a morning or afternoon of yours. So we will reset for motions hearing. I will do that. I will let you know, Mr. Hoover, that after I rule on those motions, given how long Mr. Muckle's been in custody, I may add that we are running in parallel to individual judges' calendars, a consolidated trial calendar where a senior judge comes in. It's actually what's happening right now in 1D, where that judge is focused only on the oldest of the jail cases. So Mr. Muckle's case could end up on that. I don't know that it will move faster there because all the judges get to contribute to that and you only get to do one. I had one resolved on this calendar, so I may not be up again for a while. But I know you've got a complicated schedule. I just didn't want you to be confused if it was on a trial calendar that didn't say McBurney. It's my case and I'll try it, and was hoping to do that on Monday. But I'm anxious for him to get into court. I need to resolve these motions first.
Yes, sir.
Okay. Mr. Abate, anything else on Mr. Muckle? All right. Ms. Tucson, can we hear you now? All right, Ms. Tucson, you may need to log off and log back on or get another probation
Can you hear
officer.
me okay? All right, can you hear me okay? I just.
Now we can. It's a little muffled,
Okay.
but we can hear you.
Okay.
So
Okay.
I've got a
So,
gentleman's.
Mr. Copeland,
Yes.
Yes, how you doing?
okay. So you say you wanted to suspend the balance in both cases?
Yes, ma'am. And so I don't think he's on probation for anything else. Is that correct?
That's correct. Those are the only two cases that I see for him that are active at the moment.
All right. So when he completes that, he's free and clear on that front. We've got this one unindicted case. And hopefully the state will handle that in the right way in light of this revocation. All right, that's what I needed to know. So
Okay.
will you be getting those revocation orders to me, or will you be getting this information to Officer Evans and she'll get them to me?
It will be either one of us. If she needs me to do it, I will do it. If not, I will, because she kind of already said she had all the information together. She just wanted to confirm with this hearing.
Got it.
When you guys were going to finish after drug court.
Okay, thank you. All right, thank you, Mr.
Okay,
Copeland.
thank you.
You all can take Mr. Copeland back. Yes, ma'am. Thank you, Ms. Hankins. All right, that gets us to Mr. Loomis. And we need Mr. Butterfield or,
Good afternoon, Your Honor.
there he is. Good afternoon, sir. How are you?
I'm doing very well, Judge. How are you, sir?
I'm good. What is your announcement on Mr. Loomis?
Judge, we expect that this case is going to be a plea. We just need a plea date. Here's the situation. As the court knows, when I got involved, we did the motion for a cite. The court granted that. The family wasn't able to come up with the funds to do that, but now it's not necessary because the state has come down, with a way better offer than in the past. The only issue is the family and Mr. Loomis wanted to watch some surveillance video that I guess MARTA had a certain kind of surveillance system, so it wasn't attached to the original evidence.com link. So I'm asking the court for a date where we can resolve this matter via plea. We don't expect that to change at all, based on all the evidence I know about the case and the facts of the case. So that is where we are right now, Judge.
So why is that date not March 22, 2023?
Because we don't have it. I'm going to have to get it on I'm going to have to get a flash drive, Judge, and then share that with Mr. Loomis and his family, this surveillance video. There's a couple of things in this case, Judge. When I was tasked way back when I got involved on this matter, one was there was uncertainty as to whether or not our complaining victim was still in the United States, still around. And I believe ADA Jordan, as an officer of the court, can state, and so my client can know and his family that, because I didn't share with the client any addresses. We know we don't usually do that, but if he states on the record that, yeah, we got the complaining victim. And then the other part was the actual surveillance video. We had always understood that this was supposed to be on a surveillance video. So we just need to get them let everybody see that video. And this offer is we've been back and forth with offers, and now we have gotten to the point where this is the best, and it's come a long way as far as the resolution, Judge. So that is where we are.
So how far out in the future do I need to schedule this for a plea?
The family would ask for some time, as much as time as your schedule would allow, so they can be present, Judge. They would like to be present. So that's what I was asked to ask for. So as much time as you can give them my schedule, I will be here, Judge. I'm flexible. I have some leave, but we submit a leave of absence for, I do it for the rest of the year, but it's, I'll work my schedule to whatever the court deems fit.
So if it is in April, is that enough time?
Yes, if you do it in April, Yes, I believe that'll be enough time, Judge. I'm specially set for those trial April the 4th. And I don't have any other specially set matters in April, I don't believe. If I just take a look at my calendar, Judge. Yeah, other than the April the 4th court date, I don't have any trial specially set. I have, so that's the only specially set trial. Then I have something with, that's it, Judge, as far as trials.
Okay. Why don't we try to add it the week I'm presiding? So it'll be the week of April 10th, Mr. Butterfield.
Okay.
So you'll need to work with Mr. Jordan in advance of that to make sure you get the video and you've had a chance to look at it with Mr. Loomis, because it's time to sort this out.
I agree, Your Honor. And just for Mr. Jordan, on the record, could you state, is the complaining witness currently available in this particular matter? Is he?
I'm not going to require him to. I mean, you guys can talk about that.
Okay.
You're working out. You are doing your job. If you've gotten your client a better and better offer, and you guys will reach whatever resolution you reach, and I'll see what I do with that plea the week of April 10th. But Ms. Nelson will reach out to you with a suggested time. Hopefully that works with your schedule. We'll produce Mr. Loomis. And it'll be up to you, Mr. Butterfield, to make sure his family is here. And before that time, I guess you and Mr. Loomis will have reviewed the video.
Yes, Your Honor. Thank you very much, Judge.
All right, Mr. Jordan, anything else on that case?
No, Your Honor. And to Attorney Butterfield, if you have any issues, because I know that particular Gentech video player can be kind of finicky, just reach out to me and I'll make sure that we can set up some kind of way where everyone can watch the video via my laptop if that's what needs to be done.
All right, but thank you very much, Mr. Jordan, and I'll call you after court and speak with you about this some more. Thank you.
Okay, thank you.
And Your Honor, that concludes my business for this particular calendar. May I be excused, sir?
Yes, sir. Thanks for being here.
Thank you, Your Honor.
Next up is Anthony Johnson, but that's been continued. So if Mr. Johnson is here, I need to be here anymore. Jessica.
Judge, may I be excused then?
Yes, sir. I didn't know you were going to be here. Please go be with your wife. I hope that situation is going as well as can be hoped. And we just bumped this to May. My sense was that gave you enough time to plug back into your practice. Is that too aggressive?
I hope not, Judge. I think May would be good.
Okay. If it's not, just reach out to Ms. Nelson and we'll move it one more time.
Thank you, Judge.
All right. Take care. All right. Position 7, Jessica Castillo. There she is. There's Mr. Richardson. Good afternoon.
The state has announced we're not ready.
Okay. Ms. Willingham.
Ready to reach.
Okay.
That's good, but I think the state made an offer. It's a decent offer. That's all to complete.
Sure.
Let's go work on grass.
Yes. So what we'll do, in fact, we'll do it in just a moment because then people can go their way. Let me just see what's going on. Mr. Santiago Cano, are you here? There he is. And your lawyer, I don't know if someone is online. Is anyone on the call for? Are we holding for Mr. Apt? Because I know he's got colleagues. And I think Mr. Apt is also doing YSL. That's what you.
But it is going to be a plea. So he did say that he would have someone appear. I don't know. I was under the impression that will be sometime this afternoon. But in any event, it is going to be a plea.
Okay. Is that your understanding, sir? It's resolving today? Okay. We'll reach out to Mr. Apt's office to figure out if he is going to be joining us, or I know I met a couple of his colleagues working on your case. So we will hold for that. Let me make a running list here of what we've got. All right. Ms. Castillo, if you and Mr. Richardson would come up to the podium, please. Ms. Rivers, are you in a position to take this down?
Yes, I am.
Great, thank you. This is position 7 on our trial calendar. It's 22 SC 180351. This is a 2-defendant case. We've got Ms. Castillo at the podium with her lawyer, Mr. Richardson. Ms. Willingham, can you state for the record what the state would recommend if Ms. Castillo decided to enter a plea today, and to which charges you'd be requiring her to enter a plea, and what the state's recommendation would be?
Yes, Your Honor. Should Ms. Castillo enter a plea today, the state would be moving to null price count 1, which is home invasion in the first degree, count 2, armed robbery, and the defendant would be entering a plea to counts 3, 4, and 5. As to count 3, it would be 5 years probation. As to count 4, it would be 5 years probation to run concurrent with count 3. And as to count 5, it would be 5 years suspended.
Which would run consecutive by law. Okay. So Ms. Castillo, as I'm understanding it, if you were to enter a plea today, not go to trial, but enter a plea today, the state would dismiss the 2 most serious charges that have mandatory minimums, prison, no parole, et cetera, and would go forward with the other 3 charges and would recommend to me a sentence of no jail time, be 5 years probation, and then this one charge requires 5 extra years, but that would be suspended. So you'd be on probation for up to 5 years. Let me finish, and then I'll answer any questions you got. You'd be on probation for up to 5 years, but there may well be a behavioral incentive date such that if probation was going well after 2 years, they close your case out and you move on. That's the state's recommendation now. Ms. Willingham, if Ms. Castillo elects to exercise her trial right, which she is free to do, would you still be dismissing the home invasion and the armed robbery count, or would those be presented to the jury to consider?
Those would be presented, Your Honor.
Okay, and in my recollection is that if Ms. Castillo were found guilty of armed robbery, the lowest sentence she could get would be 10 years to serve non-parolable.
That is correct.
Okay, all right. I just want to make sure I understood the pros and the cons. You raised your hand. Tell me.
Just said 5 years in total.
Oh, so it'd be 5 years probation. The gun charge has to run after consecutive, so it's 5 probation followed by 5 suspended. So there's no supervision or anything, a suspended sentence. It's just sort of out there. If you're minding your own business, you don't have a probation officer, you're not paying a supervision fee. It's just out there. But that's what the state would recommend. The lowest sentence I could give you if I disagreed with them is I could give you less time on the aggravated assault and the burglary. I'm making it up. It could be 1 year, but those 5 still have to be stacked on top, but I could suspend them. And so really what you'd be arguing, if Mr. Richardson thought the sentence should be lower, although I heard him say he thinks this is a reasonable outcome, he could argue for less probation, but that 5 years for the gun count would still have to stack on top. Do you understand what the state's recommendation would be if you entered a plea today?
You want me to answer, I agree with the plea?
I'm not asking you if you agree. Do you understand? You understand. So that's what Ms. Willingham would say when if I assume I accept your plea. I'd say, well, what do you think I should do, Ms. Willingham? She would say 5 years probation followed by 5 years suspended. Then I'd ask Mr. Richardson, I've already heard him say, I think that's pretty reasonable. And he may have already agreed he wouldn't argue for less, but maybe he'd say, I think it should be less probation because A, B, C, D. And I'd listen to him about that. If you say no, thank you to that offer and say, I want to go to trial, and I'm pointing there because that's where the jurors are. If they come back and they decide for whatever reason you're guilty of either the home invasion or the armed robbery, probation is out there, but not until you've served at least 10 years in custody with no parole. And I share that not to spook you. You may have a phenomenal case. You've got a great lawyer and you may have a great case, but I need to make sure that you understand the downside of saying no thank you to a plea. Do you feel like you understand the goods and the bads? Do you want to talk with Mr. Richardson some more about what you want to do? Okay, why don't you guys talk and let me know. I will be here all day. You're welcome. Raymond Carter. I saw, okay, they're always outside. Okay, good. My understanding somehow, maybe it's the transition from White Hour to Willingham. This is a plea.
It is, Your Honor.
Okay. Happy day. Christopher James has 3 cases and I see his lawyer. How are you? Ms. Roberts? I'm okay. How are you? Still a plea? Okay. Ready to go? Can't wait to go. All right. Well, unlike some of the others that say likely plea, you have said ready to go. And so we'll do that. I need to get through the calendar. Is Mr. James as excited as you are? Okay. Carlos Dill. I think we've already talked about this one. And is it ballistics? What? No, what? There was an issue on the state side.
Yes, Your Honor. In being candid with the court, this was one that although I am familiar with it a little bit, I am not in a place where I'm comfortable announcing ready when reached. Okay.
Ms. Feely, anything in response to that, other than you're ready?
He's ready, but I understand the positions.
Okay. Position 14 is Quindarius Rhodes.
Good afternoon, Your Honor.
Hey, how are you?
Great, he is here. We're ready to reach you.
Okay. Am I remembering correctly, Mr. Jordan? Mr. Rhodes has another case, but Mr. Smith, you're not his lawyer on that other case.
Not yet, Your Honor. We're actually going to talk after court and see if that's going to be rectified or not. But
Okay.
right now, I'm not. But I do believe he is on for tomorrow for that case.
Okay, and so that case has been indicted. It's with me. It just is behind this one procedurally. It's not on a trial calendar yet. Are the charges in the slower case or the newer case, in your sense, Mr. Smith, more serious or less serious than this one?
My thought is, and again, I haven't spoken with him, I haven't viewed the indictment other than just there are 15 counts on it. I would assume that based on the number of counts and the charges on there, that it would be either equal or more serious.
Okay, I just don't remember what the charge, if it was all jaywalking and 1 felony, it's less serious, but if it's ag assault shooting, then it's complicated.
Mostly BGCSA and gang charges.
Okay, got it. But you're ready to go if this is what goes out on Monday.
Yes, sir.
And Mr. Jordan.
State is ready, Your Honor, and that was going to be my announcement as well, is that tomorrow at 1 o'clock, 22 SC 185234 does have its plea and arraignment date.
Oh, wow, that's how new it is in the system. It's plea and arraignment.
I believe it may have been on a previous plea and arraignment calendar, but then 88 Hiles re-indicted it, so it kind of had to start over again in the cycle. But the state is ready on this position, Your Honor. We would just, if Mr. Smith is retained on the other case, we would ask that both of these cases have the opportunity to travel together, because then I believe we would be able to come up with a global resolution on both cases. But we would be ready if we.
Okay, they'll travel together if Mr. Smith gets hired by Mr. Rhodes, but our list of what might be tried on Monday is shrinking because we're getting some good pleas. And so right now, Mr. Rhodes is high on that list and he'll decide what he wants to do with Mr. Smith in connection with the other one. I would not expect anyone to be ready to try the other case, obviously, but that might factor into, well, maybe now there is a need to work out this case too. We'll see.
Yes, sir.
Okay, thank you. Yes, and I guess, Mr. Rhodes, you're going to be back tomorrow. All right, see you then.
Your Honor, it's my understanding that tomorrow's a Zoom. Is that a Zoom hearing for you?
He can attend.
Okay, Zoom is fine. If you can make Zoom work, that's fine.
Thank you.
All right. Mr. Dawson. He's here. Good. Your lawyer is stuck in traffic or in court?
Yeah, he in court.
Yeah, so he's letting us know. My understanding is maybe your case is working out today?
Yes, Your Honor.
Yeah, so we just need Mr. Arca to make it here. And so hopefully you don't need to be at work right away. You done with work for the day or you're supposed to be?
Down at 4.
Oh, well, you're probably done with work. When do you have to be at work?
No, I get off at 4.
4 PM? Yeah, so you're probably off for the day, because I don't know when Mr. Yeah. Okay, good. All right, so sit tight, Mr. Arco will get here. Malik Henderson. And I know we have his 19 lawyers on the call here.
Good afternoon, Judge
There's not
Matthew.
19. Is that some sort of reference to my broad shoulders and powerful presence?
Now, that would have been 3.
Ah, okay.
And Ms. Kaufman, I think you're on as well.
She's just getting off set and logging in, and Mr. Ensland from Cobb is here as well.
I see that. Okay. And we have a guest visitor from the DA's office. So let's start with the state. I saw your motion.
Good afternoon, Your Honor.
Good afternoon.
Matthew Holmes on behalf of the state, yes. Judge, I filed a motion request from the court for continuance on the 14th. I am handling the SB 440 unit while Deputy DA Shane trying this out. That will end on April 10th. And so my request from the court was a 60-day continuance, allowing her time to get kind of caught up to speed on everything that's happened. They're being out since the end of last year, and then preparing what I think was, and I've had conversations with Ms. Kaufman about a resolution. I think the one thing that we had sort of a placement with the I can't remember if it's Army or Marines, maybe the Marines, didn't work out, but we're still sort of negotiating with that. So given all of that, that's why I filed, Judge.
Ms. Carey had been working on the case for a while. I had spent some time interacting with her and defense counsel. Is she not on the case anymore?
So she was appointed judge. So she is.
Holy smokes, where is she a judge?
I think she's with the city or I think it's a municipal judge. But I think it's local. So,
Oh.
So she is no longer with our office. So I am that's before 40 unit is me until I can join my
Okay. Well, congratulations to her. And it looks like she's with the magistrate court here in Fulton County. All right, that's her choice. So I don't know who the lead spokesperson is amongst the many voices for Mr. Henderson. Hopefully you could hear what Mr. Holmes was saying. Even if you couldn't, he did file a motion. So it's in the docket. What is the defense perspective about whether we ought to try this case starting on Monday or wait for Ms. Trotty to get up to speed?
Judge, we were actually planning to wrestle for which one of us got to speak with you. We know how precious and rare your time is these days. We have no problem with a reset. This case is not ripe for trial. Mr. Henderson, we have been diligently working for an alternative to the penal system or prosecution as a resolution for this case. We've already presented a number of options and are working based off our prior conversations on getting the right programming for this man in order to keep him on the right pathway to being a successful adult. We really want to get this case back to juvenile court with that program, strike a deal and be done with it. I as much as I enjoy Rachel and Matt, we have many other cases. So if 60 days works for the state, we're great with that. In the meantime, we would ask that the court consider a bond. This young man has no holds. He was viciously attacked while incarcerated. Rachel can speak at length about some of the torture, and I guess his mother is present there. The time incarcerated has affected him in a really awful, negative, dangerous, and bad way. So we definitely want 60 days. We want to get this sent back to juvenile court, and we'd like a bond that we can make. so this young man can help us with the applications for the programs. So many of them want to spend time with him before deciding or in order to evaluate the appropriateness of that pathway.
Is his current location working better than his previous location in terms of safety?
Rachel?
Well, so I don't know if Matt's on here, but my understanding is his business is now done in Cobb. So there's a concern that he's going to be sent back to Fulton, unless I possibly, Your Honor, had him sent there via an order anyways, which I can't remember exactly what we did. But if he's in Cobb, I guess he can be held there without bond at this point. But if he's going to be transferred back to Fulton, it's even more imperative that if Your Honor isn't willing to consider it today, that we schedule a time to be heard on bond, sooner than later in the next 60 days, to try to facilitate him getting into these programs and moving forward, which is what I think the state wants too. We just weren't able to get it all done before Miss Carey left.
Got it. So my question was, has Cobb been better for him than Rice Street? It sounds like the answer is yes, which is why you'd be worried about him returning. As of now, Mr. Henderson is still there. What I'm going to do is have Mr. Henderson's case move to a future trial calendar, but invite you all to get the case back in front of me before then. If one of two things happens, one, you sort it out. Let's get everyone in here and resolve it. Or two, Mr. Henderson's living situation changes. If he is going to be relocated, I think he's in Cobb for two reasons. One, he had business there, and two, we asked real nicely, could you please move him there? And so I suspect he'll stay, but if that changes, that's another reason why we'd need to get into court. And then the state could be put to the task of answering, well, we weren't ready, but we don't think he should get a bond yet. And if they're aligned with you in terms of connecting him with a program, maybe that would be a different proposition. But I'm going to maintain the status quo as long as it is the status quo. It's not if Mr. Henderson is relocated. I assume that works for you, Mr. Holmes.
That does, Judge.
Okay, someone has stood up in the back of court. Yes, ma'am.
Hi, Ms. Mom.
How are you?
I'm okay.
Okay, I can understand that.
So Malik has suffered a lot since he's been there. And I really, really want my kid home. Like, I know he's grown to you guys, but he's my 18-year-old kid. And I know he made some silly mistakes, but I really hope he can get a bond and come home, because it's not only affecting Malik. It's me every day hoping to God that nothing's happening. It's Malik still suffering mentally from everything. And I just hope that a bond can happen fast. And maybe a leg monitor. I will stay home every day.
Okay.
I don't care, but I just really need this.
Well, I appreciate you articulating that. And he's not just a guy to me. He's very young. I have a kid, not quite that old yet, but boy, he's still a kid and is going to be for a long time. So I'm not thinking he's this hardened guy who can survive just fine in there. It's not the point at all. These charges are real serious, and they are also not to be taken lightly, neither his life nor these charges. You've been fortunate to assemble a very, very effective trial team, and they're working hard on your son's behalf. And I've shared that I'm open to considering something different, but I would need to know more about why a bond would be appropriate in the face of these serious charges. And today just isn't the day to work through that. So I wasn't saying no to it, but if your son is in a stable situation, not a supportive situation, but a stable one, it seems to me like maintaining that while the lawyers continue to work hard to line up whatever this program looks like, and convince the state, and the state has to agree to it. I will participate if there's going to be a plea, but your son can't plead straight up to these charges because that's a 25-year sentence. It would require the district attorney's office to agree to reduce it, or as Ms. Kaufman said, to send it back to juvenile court. And those are decisions uniquely vested in the district attorney's office. So I will come into play if your son gets relocated, or if the state again says, we're not ready. But right now, and I understand why they're saying this, your lawyers, your son's lawyers are saying, we would like Ms. Trotty to learn more about the case, because the more she learns about it, the more likely she will be supportive of the approach that your son's lawyers are developing. So I remain open to revisiting what we do. But for now, I'm going to keep Mr. Henderson where he is. This will go on an upcoming trial calendar, but it does sound like people are very focused on a non-trial resolution. Let's not wait for that trial calendar date. Let's get Ms. Trotty where she needs to be in terms of comfort and get something put together and then bring it back to me, whether it's a return to juvenile court or here is a non-trial resolution that doesn't result in Mr. Henderson serving 25 years in prison with no parole. That doesn't sound like a real productive outcome, but I don't know the facts of the case. It may be that 100 years without parole is the right sentence. We do need to hear more about the case. So defense team, are you all right with that? You'll let Ms. Nelson know if we need to do something different, but my plan will be to get Mr. Henderson on an upcoming trial calendar, remembering what I've known for a while, that the defense is working very hard at a non-trial resolution.
Yes, Your Honor.
Great. All right. Thank you.
Judge, that concludes all of our business. May we please all be excused?
Everyone but you, yes.
Did Judge Roth get to you? Because he would do that to me all the time, and he puts it up to the gallery as a vote. Very
Nah, I won't put you, because then you'd be here all night. You can go too.
Thank you so much, Judge. Wishing you and everybody else a great day, and thank you again.
Jamel Lewis. My notes, Ms. Feely, were ready-ish. Okay, you're ready.
Based on what I have so far.
Okay. And I'm just not remembering, Mr. Abate, what, is this a ballistics?
Yes, Judge, we were able to get the ballistics tested and we provided a report to Ms. Feely, I believe this morning. Nothing life-changing or earth-shattering.
Okay, and that was the one outstanding piece?
Yes, Your Honor.
Okay.
We have extended an offer that is much less than the mandatory minimum. I know Ms. Feely may need some more time to talk with her client.
Have you had a chance to talk with Mr. Lewis about that? Okay. If this went to trial, how long would the trial go?
3 to 4 days, Your Honor.
Not into Friday or TBD?
I don't believe, in all candor, I don't believe it would go to Friday.
Okay. Would you be trying it or would you have assistance?
That is
TBD. Okay. All right. Well, I'm going to keep it on the list of could be doing it. But you should certainly talk to Mr. Lewis about the improved offer. Okay. Adonis Hurd.
Afternoon, Your Honor.
There's Mr. Hurd. There's Mr. Katz. Mr. Katz, I think I told you last time, if you made the mistake of appearing again, I was going to assume you're in a position to try the case and we weren't going to wait on the elusive Mr. Harvey.
Yes, Your Honor. Actually, I'd planned to be in Israel next week for a family event, but that is exactly what you told me.
Okay. What is the state's announcement on Mr. Hurd's case?
Your Honor, I have reached out to Mr. Harvey, but I recognize he's in a bit of a big trial right now. But I do still think this is something that we'll likely be able to resolve. I just need to be able to speak with Mr. Harvey.
Well, Mr. Katz, are you sufficiently deputized by Mr. Harvey that Ms. Willingham should be trying to contact you to see if the case can work out?
She can do that. Yeah, absolutely. And I have no trouble getting a hold of Mr. Harvey by text because I think he's just kind of sitting in YSL.
Okay. What's the best way for Ms. Willingham to contact you?
Probably just my office phone or my cell phone. I could send it to her in the chat.
Yeah, why don't you do that? Well, you could send it to me. I don't think she's logged in, but if you send it to me, I'll just write it down on a note card and give it to Ms. Willingham, and then she can reach out to you.
Thank you, Your Honor.
You bet. So Mr. Hurd, your case is going to remain on the short list because there's not much else on it. Mr. Katz or Mr. Harvey will be in touch with you, but you may need to be here on Monday so we can move your case forward, okay? Any questions? All right, thanks for being here.
Thank you, Your Honor.
You bet. I'm going to give your number to Ms. Willingham and you are free to go. Well, before you go, so you said you have plans to be far, far away. That typically involves plane tickets and all sorts of stuff that are lots of money. Do you have a boat and that's how you're going to get there? So it's no cost if you don't go, or how is it that you would be here instead of there?
Well, Your Honor, this was decided about a week ago because of my wife is Israeli and her father is 98 and, you know, not doing great. And so we said, look, we'll try to go during the Passover holiday. But that's how that came about. And we do have flights scheduled.
Okay. And who's your backup when Mr. Harvey palms something off on you? To whom do you dish it?
I don't, Your Honor. I don't. I think, you know, I understand this case needs to move and
okay.
I understand. I well understand the court's concerns about cases moving. I just would hate for Mr. Harvey to be in the position of having a very angry Israeli woman after him.
Got it. Well, why don't we do this? Ms. Willingham's going to reach out to you, and it may well be that there is a non-trial resolution. And I also understand that Judge Glanville doesn't have court 8 hours a day, 5 days a week. And so it may well be that Mr. Harvey and Mr. Hurd could figure out a way to get here to resolve the case if that's happening.
And Mr. Harvey may have had discussions that I'm unaware of as well. Sometimes he doesn't tell me about those discussions. So I'll get up to speed very quickly, Your Honor.
Okay, thank you.
Okay, you too.
All right, I think we are in a position to take some pleas. Mr. Santiago Cano, Mr. App is still stuck in, okay, just let him know that Mr. App is planning on being here, but it won't be for a little while. So no one's forgotten about him. Okay, Ms. Roberts, should we do Mr. James? You expressed such eagerness. All right. Mr. Jordan, are you ready to do the pleas in Mr. James's cases?
Yes, Your Honor.
Was there anyone in here whose case I didn't call? No? All right. Then let's do it wherever it makes the most sense logistically. Probably if we move some of those chairs out of the way. Okay. Oof. Ms. Rivers just needs to be able to hear him. So I think if he sits next to you by that microphone, we'll be good. All right, let me find what we've got here. All right, Mr. Jordan, are you ready?
Yes, Your Honor. If I can just briefly talk to Ms. Roberts for just 1 second. The
You're not calling Ms. McCauley in here, are you?
No.
Okay.
On 22 SC 181407, that will be reduced to 2 misdemeanors. That was 88 Willingham's case. I just wanted to confer with her to see which 2 misdemeanors those.
Okay, great. So have that quick conference and then we'll get things on the record.
I can say it's back.
Okay.
Too bad.
2 back to 2 counts of battery. Okay.
Okay, that was easy. Then let's get on the record. These are positions 10, 11, and 12 on our trial calendar, all of them State versus Christopher James. One indictment ending in 803, one in 107, and one in 244. Ms. Roberts is here on behalf of Mr. James. Mr. James is at counsel table. Mr. Jordan will be handling the pleas. Mr. James, I'm Judge McBurney. We've seen each other every once in a while, but it's been a minute. Ms. Roberts tells me you're prepared to resolve your 3 remaining cases by way of a plea. Is that correct?
Yes, sir.
Okay, I need you, Ms. Roberts, if you'll tap the microphone in that little, nope, not the, there's a little depression. And then if you remove your finger, it should turn green. Excellent. Now it's on. That'll make it easier for Ms. Rivers to hear you and Mr. James. Mr. James, for us to take these pleas, Mr. Jordan needs to put you under oath, which he'll do in just a moment. Once you're under oath, I need you to be sure you're answering questions truthfully and completely. And if at any point during our conversation, you need to speak privately with Ms. Roberts, let me know. Or if you've got any questions about anything, will you let me know?
Yes, sir.
Great. And you're welcome to remove your mask if you want. That's up to you, but we now have a no mask requirement in the courthouse. It'll make it easier to hear you with the mask off. All right, Mr. Jordan, please.
Thank you. Mr. James, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name?
Christopher James.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
30, ninth grade.
Okay. Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with the following offenses? In your honor, would you prefer for me to read out the indictment numbers or only the ending of the indictment?
I can just last 3 digits will be easier for the court reporter.
An indictment ending in 803, you are charged with 3 counts of possession of firearm by a convicted felon. An indictment ending in 107, you are charged with 1 count of aggravated assault, 1 count of arson in the 3rd degree, 1 count of possession of firearm or knife during commission to commit a felony, and in the final count, possession or receipt of a firearm by a first offender. And for indictment ending in 244, you were charged with 4 counts of criminal damage to property in the 2nd degree, 1 count of possession of firearm by a convicted felon, and 1 count of receipt, possession, or transport of firearm by a convicted felon. Do you understand that you have been charged with all of those offenses?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Renee Roberts, about all of the facts and circumstances known to you regarding the charges in these indictments, including
sir.
any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Ms. Roberts, do you waive formal reading of these indictments?
So waived.
Do you waive any and all defects in the indictment, including any with respect to Mr. James' name?
So waived.
Mr. James, do you recall having being arrested on these charges?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Roberts, do you know of any outstanding warrants related to these charges?
I don't.
Thank you. Mr. James, has your attorney advised to you the minimum and maximum sentence for each charge that you are pleading to?
Yes, sir.
And Your Honor, just for the record, for the possession of firearm by a convicted felon, That is a minimum of 5 years and a maximum of 10 years. Your Honor, this is a forcible felony that was alleged on the indictment. I did.
You're referring to which case?
My apologies, Your Honor. The indictment ending in 803.
Okay,
And
there's
Your Honor,
no, I mean, you're saying the underlying felony?
Yes.
Okay, got it.
That's correct. And it does say in the statute that it is, shall be in prison for 5 years, but I did read in Langley v. State, and I can make sure to send you that citation, that a trial court would be in its discretion to probate that sentence.
Okay.
And Ms. Willingham, for the 107, can you advise which counts are being reduced to misdemeanor?
Sorry, hold on a second. It is going to be, count 1 is going to be reduced to the misdemeanor battery, and count 4 is already a misdemeanor battery. So the other counts will be non-processed.
Thank you. And
So we're only proceeding on 1 and 4.
Yes, Your Honor.
The plea to the indictment ending in 107 is effectively a misdemeanor plea.
Yes, Your Honor.
Okay.
And for the indictment ending in 244, and my apologies, Your Honor, for those misdemeanors, the minimum is 1 day and the maximum is 12 months. For the indictment ending in 244 for criminal damage to property in the second degree, the minimum is 1 year and the maximum is 5 years. And I believe for the possession of firearm, there is a possession of firearm during the commission of a felony that's on that indictment as well. That is 5 years consecutive. And for, as previously stated, the possession of firearm by a convicted felon is a minimum of 5 years and a maximum of 10 years. Mr. James, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, beginning with the easiest indictment, since it's a misdemeanor reduction on 22 SC 184107 for counts 1 and 4, those will be 12 months to serve. Mr. James has been in custody for approximately 856 days, I believe, Your Honor. I may be slightly off on that.
It's probably a little bit more, but it's in the high 8s.
Yes, Your Honor, that's correct. So that, on that particular case, that is 12 months to serve. Credit for time served, he has served over 12 months. For the possession of firearm by a convicted felon, the recommendation for that case, Your Honor, is 8 to serve 3, commuted to time served. I believe he's been in around 26 months, I believe. So 8 to serve 26 months works better, Your Honor.
Hello,
Hold on 1 second. Yes, ma'am.
Miss Willingham, your papers are picking up a lot of sound. Sorry.
All right. Back to you, Mr. Jordan. Thank you.
Yes, so for the indictment with only the possession of firearm, which is ending in 803, the recommendation for that case, Your Honor, is 8 to serve 3, commuted to time served, with the balance being probated. I do believe that Mr. James is currently on probation. We would ask that you run that probation, the probation for these cases concurrently with the 14 SC case that he's on, Your Honor. I had that case number. I do apologize. I must have left that note over at the table.
Well, it's in the indictment for it's 14 SC 127866.
That's correct, Your Honor. So we would ask that all probation run concurrent with that case. And Your Honor, on the indictment ending in 244, the recommendation for every single criminal trespass count is 3 years to serve.
When you say criminal trespass, the criminal damage to property?
Yes, Your Honor.
Okay.
That's correct. The criminal damage to property. The recommendation for that case, Your Honor, is, well, for those counts, Your Honor, is 3 years to serve. And my apologies, Your Honor, if I can just pull up. For counts 1 through 4, the recommendation is 3 years to serve, commuted to time served. For count 5, which is possession of firearm during commission of a felony, the state's recommendation is 5 years probation consecutive, to count one. Your Honor, if it is easier, because I know the other case is 8 to serve 3, and we wanted to make sure that this was a global offer that was just 5 years, the state wouldn't be opposed to suspending that, just so we're clear that it was only supposed to be a balance of 5 years on probation or 5 years and some change. And the recommendation on the possession of firearm by convicted felon count on indictment ending in 244 is 3 years to serve.
Okay.
Mr. James, was that the negotiated recommendation that was communicated to you?
Yes, sir.
You understand that the court does not have to accept that recommendation?
Yes, sir.
You understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, sir.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, sir.
And you are aware that you are currently on probation?
Yes, sir.
Do you understand that your probation may be revoked based on you entering a guilty plea today?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, finally, the ability to obtain employment?
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm during the commission of a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health offenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
And it is my understanding that you intend on pleading guilty under North Carolina v. Alford, is that correct?
Yes, sir.
As to all the cases or?
To all of the cases, Your Honor, I believe.
Okay, I mean, I guess I'll need to hear the facts, but Mr. James, an Alford plea, which I can accept, is a plea when a defendant says, I didn't do all the things the state said, or it went down a little differently than what the state says, but I still want to work this out. So I'm going to make this up. Maybe one of them where you're charged with hitting someone, maybe you got hit first and you were just sort of pushing back a little bit, but you know what? I don't want to sit in jail anymore. I'm going to plead guilty to battery. I can accept that. But what I'm hearing is that you want to say, I really didn't do any of these things charged in any of these cases. I'll hear the facts in a minute, but let's take the real simple one. The case with the 3 guns. Man, either you had the guns or you didn't. And maybe it's going to be there were 3 people in the car. And for whatever reason, the police stuck all the guns with you, but they just as easily could have stuck them with another guy in the car. It's not typical that someone has an Alford plea to all 3 cases. It's usually a little more surgical. Like I didn't really hit her, but it's not worth it because I got these more serious cases. And so I'll take an Alford plea in the case where it's just battery. So I share all that because I may push back a little bit after I hear the facts about whether I'll accept an Alford plea on all 3. But it may be that there's craziness in all 3. I know the one that was most serious of all, the state dismissed. So you could have been in the wrong place at the wrong time 4 times. We'll see. All right.
Okay, sir.
Mr. James, are you pleading guilty under North Carolina v. Alford because you have decided that is in your best interest to do so?
Yes, sir.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, sir.
Mr. James, how do you plead to the charges of 3 counts of possession of firearm by a convicted felon, an indictment ending in 803?
Yes.
How do you plead to 2 counts of battery and indictment ending in 107?
Yes.
How do you plead to 4 counts of criminal damage to property in the 2nd degree and 1 count of possession of firearm during commission of a felony, an indictment ending in 244?
Yes.
Thank you. Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
For the felony charges that you're pleading to today, do you understand that you only have 4 years to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And do you understand that for the misdemeanors, you have only 12 months from today to file that same petition?
Yes, sir.
And Ms. Roberts, have you explained to Mr. James his deadline for filing a direct appeal?
Yes. Yes.
Thank you very much, Your Honor. And beginning with a factual basis on 23 SC 186244. And my apologies, Your Honor, I did leave out in the global that on the 244, which is the case I'm about to give a factual basis for, the state did want to ask for a restitution hearing to be heard within 60 days. We have gotten only 1 estimate for damages so far, even though this happened in 2020.
Yeah, okay.
But we have spoken to the individuals that were involved in this, and they claim that they would have damages to give to the state. So we would just ask that a restitution hearing be had within 60 days.
Okay.
And also that Mr. James not return to this auto zone, which I'm about to give the incident location to.
Okay.
On May 14th of 2020, an officer from the Atlanta Police Department responded to 689 Cascade Avenue, which is an auto zone, regarding shots fired. When the officer arrived on scene, he met with the witnesses. No one was physically hurt, but people's vehicles were struck by bullets. The officer spoke with a Mr. Harry Daniel, Harry. Last name Daniel has normal spelling. Carl Davis, both of those names have normal spelling. Lamarck Tucker, Lamark, last name Tucker has normal spelling. And Wayne Mitchell, Wayne and Mitchell have normal spelling. We're in the parking lot when the incident occurred. They advised that a male by the name of Juju was arguing with another male. During the argument, a male later identified as Juju went inside of a black book bag and pulled out an assault rifle and began shooting at the unidentified male. The male pulled out a pistol and shot back. According to witnesses and victims, neither male were injured, and Juju did jump over the fence and ran towards Rogers Avenue. Mr. Tucker stated that he recognized the male as Juju. He believed that Juju's real name is Christopher James, and stated that at that time he was staying on Montreat Avenue, Montreat Avenue. 4 vehicles did sustain damage from the gunfire. A total of 19 shell casings were left on the scene. The owners of the vehicles were the previously mentioned Mr. Davis, Mr. Mitchell, Mr. Daniel, and Lamarck Tucker. As of today, Your Honor, only Mr. Mitchell has provided an estimate for his damages. Your Honor, in regards to this case, there was initially an aggravated assault that was attached on this case. The victim for that particular count, or perhaps not a victim, never wanted to participate with officers. We did not present that charge to the grand jury. We did feel that in a case like this, that a jury may have concerns with us not having the other individual whom the shootout was with, present in court. So we did believe that the most important thing here would be restitution, getting Mr. James out of that area, and making sure that everyone that was affected by that situation, that they got proper restitution. Your Honor, for the case ending in 803, it was somewhat connected. At that time, which was in November, Your Honor, Mr. James had been identified by one of the individuals from the AutoZone incident. A search warrant was applied for the location of 933 Ridge Avenue Northwest. This search warrant was secured because officers did listen to jail calls from a Miss Calandra, and I believe that's Calandra, last name Owens. Miss Owens was talking to another individual who was in custody. Officers did hear her state that Mr. Christopher James, or Juju, was staying at that house at that time, or at least residing at that house very often. Police officers were able to follow his car to that location as well, and did see the vehicle parked there as well, or a vehicle that he was known to have driven on a consistent basis. So as a result of this search warrant, Your Honor, officers did and make entry into the home. There were 2 adult females, 1 male, and approximately 7 children in the house. Mr. James did refuse to come out when officers first approached the house. Your Honor, they were able to retrieve Mr. James from inside of the house. He did eventually come upstairs where he was retrieved by the fugitive unit. In the basement of the home, a mini Draco semi-automatic pistol was found, a Scorpion pistol, and there was also a car arms handgun, which were located, I guess you would call it an entertainment center, Your Honor, under the entertainment center. Officers basically determined in their investigation that because Ms. Owens at some point came up to talk to the officers and tried to get her cell phone from the basement, when the officers allowed for her to get the cell phone, she retrieved another phone. They asked who that was for. She said it's for my brother, which is what she referred to Mr. James as. They asked her, does he stay down here? She says, yeah, we're both here. We're both in and out. So officers did feel like because they executed the search warrant on the home and the guns were found in the basement, they believed that it was sufficient to say that he was within arm's reach of those particular guns. That's how he was charged with possession of firearm by convicted felon in that case. And Your Honor, would you still like the factual basis for the misdemeanor plea, or is it okay if we stipulate to the facts on that case?
If you don't mind stipulating to the facts this would be the batteries?
Yes, Your
Honor. Yeah. So I'll stipulate to that.
Okay.
So that's, Your Honor, I know Mr. James has had a large amount of cases in front of Your Honor. Each one has had their particular issues. Mr. James has been in custody for a long time. I know that on this particular case that the possession of firearm by convicted felon case was going to be very circumstantial, the evidence to draw him to the guns, placing him within the basement. I do believe that he says that he comes up the stairs, but given where the guns were under the entertainment center, it may have been a stretch for the state to be able to prove that he was within arm's reach of those guns. So our main concern here, Your Honor, is that Mr. James just get on the right track and that he be able to pay the restitution once we provide the full estimate of damages. And we ask that Your Honor accept this negotiated global plea.
The case for which there's a stipulation for a factual basis has a victim, Ms. Martin. It's alleged in there that Ms. Martin is the mother of at least one of Mr. James's kids. Do we need to have a stay away or a no violent contact, or what do we have, Ms. Willingham, from the state's perspective vis-a-vis Ms. Martin?
There were special conditions. It is a no contact, Your Honor, but I want to make sure I do the correct ones. So I'm gonna go back to the email that I sent.
So you're aware, I have no objection to no contact. I'm advised them to take a TPO out because their relationship is problematic.
It's a mutual situation.
Yes.
Okay. Mr. James, how many kids do you have with Ms. Martin?
One daughter.
One daughter with Ms. Martin?
Yes, ma'am.
So you understand that if I impose no contact with Ms. Martin, that'll make it complicated for you to see your daughter. You'd need to arrange through someone else to get your daughter. You could spend time with your daughter, but you couldn't call Ms. Martin to say, hey, what's your daughter's name?
Mariah.
Mariah. I want to see Mariah. You calling her would be violating your sentence. So there'd need to be a third party, your mom, her mom, someone, an aunt, who you'd say, hey, when could I see Mariah? And then that person would contact Ms. I know it seems kind of drawn out to do that, but no contact means no contact. It's okay to call her about the kid because the kid is often where stuff blows up. I can't believe you didn't get diapers. And
Yeah, that's what we got going on right now anyway, so that won't be a problem. I communicate with her through my auntie.
okay, good. And that's how you'd get to see your daughter.
Yeah, that's how I do it.
Okay. Was there anything else, Ms. Willingham?
Your Honor, in my initial email, I did also ask for, I say that because I don't know, we had a lot of change, so I want to make sure Ms. Roberts was aware. But in my initial email, I also did ask for family violence intervention.
Okay.
I didn't recall that.
All right. That's 107. Okay.
I didn't recall seeing that in the email, so I would want to verify that it is because the reason why these cases are misdemeanors because this is not exactly what happened and what occurred. It's just like a bitter baby mama and problematic relationship. It's part of the reason why this case was reduced, Your Honor. He doesn't have a problem with violence towards his children's mother. So I would object to that. And respectfully, I didn't see it. I don't know if you put it in. It was a lot of exchanges, but that's not something I anticipated. And I did not discuss that with Mr. James.
Okay. I'll take it under advisement. Anything else? Okay. All right. Anything else, Mr. Jordan?
Nothing further from the study, Your Honor.
Okay. Thank you. A lot of moving parts here. Let's turn to Ms. Jackson. Good afternoon, Ms. Jackson.
Good afternoon, Your Honor.
How many cycles does Mr. James have?
11 cycles.
And how many, I know of one conviction, there's this 14 SC for aggravated assault. How many other felony convictions do you have for Mr. James?
I see one in 2009 for burglary. That's it, Your Honor.
So a total of 2?
Yes.
All right. There was a recidivist notice. It had also supposedly an aggravated assault in 2010.
That's correct. There was one, I thought you had that one. I apologize.
No, that's okay.
That was one in 2010 for aggravated assault. And it seemed like there was a possession of a firearm by a convicted felon. And the one that's in 2009 for burglary.
Okay. Got it. So 3 priors, 11 cycles. Excellent. Thank you so much.
Yes, Your Honor.
Ms. Tucson, Mr. Jordan was thinking that Mr. James was still on probation in one of those cases. Is he?
Yes, Judge. He is on probation for 14 SC 127866. And on that case, there are 15 years, 11 months, and 18 days remaining.
Wow. All right. That's a long sentence. Thank you. Ms. Roberts, what do you want to tell me about Mr. James?
Yes, Your Honor. First, I want to thank both ADAs. This was a real big project. But Your Honor, in the reason why my client is taking the Alfred plea, Your Honor, is in the first case, well, the case ending in 244, the criminal damage where there is no victim. My client is just taking that plea because that's in his best interest, because he, was in that area. But there is no direct evidence that shows that he was shooting. And like what was stated, there was 19 shell casings found. So although my client, his position is he wasn't shooting, but there was a shootout. And if you're in the area, that's circumstantial. So it's in his best interest to, take that plea.
Okay.
Also, in the possession of the firearm case, Your Honor, I'm not going to dispute, but I didn't see it. I don't know about this jail call, but I did view the body cam footage, and Ms. Owens did state that Mr. James did not live in the residence and that there's multiple people that be in the basement.
I get with the 803, that's the case number. There are 3 guns found underneath an entertainment center in a house with lots of people in it. So I'm okay with that. And then the 107, I now understand better. It sounds like that was a contentious, tumultuous relationship. And that was the one that to me made the most sense. Knowing none of the facts would be an Alfred plea, but I'm not pushing back anymore on that.
Okay, thank you, Your Honor. And my client has 3 children. He was an active father before all of this happened, and he has 2 sons as well. And so we'll just respectfully, Your Honor, ask that you accept this negotiated plea.
Okay. Mr. James, remind me, I know you had surgery recently. Did something bad happen to you? It was I don't want you to share personal health information, but are you doing okay? And are you expected to recover?
Yeah, I just fell down the steps and I had broke my leg. So they had did a surge on it. So right now I got like 6 weeks left. I can put pressure on it.
But did the doctors think in the end you're going to be walking again?
Yeah.
Okay.
Everything will be good.
Something that happened while you were in custody?
Yeah, it happened since I've been in the right street.
Okay. I guess it has to, because otherwise you would have had a broken leg for 2 years. So that would be painful. All right. Mr. James, I find there's a factual basis for each of your 3 pleas. I understand it's an Alfred plea, but if the state went forward with any of these cases and could prove what they alleged, a jury could find you guilty. I think you've got some good defenses in some of them as well, but I don't know that you'd succeed in all 3. And so I understand why you're entering a plea. I'll accept your plea as an Alfred plea in each 3 cases. I also find that your pleas are knowing and voluntary. Voluntary means no one's forcing you to enter these pleas. And knowing means that you've understood all the things we've been talking about. Do you have any questions so far?
No, sir.
All right. I'm sentencing you pursuant to the Probation Options Management Act. That means that while you're on probation, which you will be for a while, if you have a minor or technical violation, you and probation will work through that. But if it is major, that would be a new arrest or a violation of any special conditions that I impose, then you would be seeing me instead of probation. Mr. James, do you authorize my staff to sign each of the indictments indicating your offered plea on each one?
Yes, sir.
Yes, Ms. Roberts, can we sign for you?
Yes, Your Honor.
And Mr. Jordan?
Yes, Your Honor.
Mr. Jordan, you filed a notice of recidivist in at least one of the cases. Is this a recidivist? It can't be a recidivist sentence because what you've recommended wouldn't fit. So I assume you're withdrawing that for purposes of this plea.
Yes, Your Honor, that is correct. I believe I filed it on the indictment ending in 803, and the state will be withdrawing that recidivist notice.
Okay. Ms. Roberts, I think it makes sense for me to do a mini revocation in the 14 SC case based on these 3 new convictions so that Mr. James doesn't get partway home and then there's a probation warrant because he now has 3 more convictions. My plan would be to revoke 2 years credit for time served and reinstate the balance. But I cannot do that unless you waive on behalf of Mr. James his due process notice rights, because there is, as far as I know, there's not a probation warrant. Certainly this wasn't calendared for a revocation hearing.
We'll be waiving it, Your Honor.
Okay. All right. I'll add that on at the end. Okay. So in terms of sentencing, let me start with the case ending in 803, that's the 3 guns found in the basement. And I'm going to sentence you on each of the 3 counts to 8 years to serve 2 years and 4 months with the balance probated. 8 years to serve 2 years and 4 months with the balance probated. You'll get credit for all the time you've been in, and you've been in just under 2 years and 5 months. So you've already done 2 years and 4 months. So I'm not reducing anything to time served. You've served that amount of time. Those counts all run concurrently with each other. On your probation, special condition number 1 will be that you have no contact with Markeisha, Markeisha Martin, standard spelling, mother of one of your kids. She's actually not named in that indictment, but you're not going to have any probation on the case in which she's named in the indictment as the alleged victim. So I'm tucking it in there. I'm also, Mr. James, going to have you submit to a mental health evaluation. And if any professional you meet with, a doctor, a psychiatrist, or someone recommends any course of treatment, counseling, or anything like that, that treatment will be a condition of your probation. That is it, I think, for 803. Oh, 803. Yes, that's it for 803. In the case ending in 107, 22 SC 184 107, you've pled to 2 misdemeanors, and your sentences there will both be 12 months to serve. Those will run concurrently with each other, and you'll get credit for time served. You've done more than 12 months. So that case is closed out. Finally, in the case ending in 244, 23 SC 186 244, your sentences in counts 1 through 5 are 2. Let me make sure I got that right. I think it's 1 through 5. Where's that?
It is, Your Honor.
Yeah, 1 through 4 and 6. 1 through 4 and 6 will be 2 years and 4 months to serve. And your sentence on count 5, which has to run consecutive, will be 5 years, and it's probated. So that sentence is a little bit shorter than the other one. It's 7 years and 4 months, serve 2 years and 4 months of those. So counts 1 through 4 and 6, serve 2 years and 4 months, all concurrent. Count 5 has to be consecutive, has to be 5 years. That is probated. Special condition of probation in that case is stay away from the auto zone at 689 Cascade Avenue, where these 4 cars got shot up. We'll have a restitution hearing if you file something to that effect, but that's going to require the state to act, the state to get evidence, and if they do, I'll convene it and we'll see if any restitution is owed. I'm not ordering any now because there's no record made that any restitution is owed. And finally, in 14 SC 127866, I am revoking 2 years and reinstating the balance. The basis for that revocation are your 3 convictions that you got today. All of these cases are intended to run concurrently with each other. So you're just going to have some additional probation that's running at the same time with a very, very long probated sentence in that 14 SC case. Stay away from Ms. Martin. You'll get your mental health evaluation. Stay away from that auto zone. And if you are not released from custody in the next few days, you should call Ms. Roberts, because I don't think there's anything else holding you in. I will tell you, you've had more cases than most, so I'm not promising you there's nothing else holding you in. But I don't think there is. And so if you're still there and it's Friday, Saturday, call Ms. Roberts. She'll reach out to my staff and we'll figure out what the hangup is. Mr. Jordan, anything else?
Nothing further from the state.
Ms. Tucson, what do we need to share with Mr. James about reporting instructions?
Just so I'm understanding, he will not be held much longer, correct?
Well, the sentence I gave him, he's completed. He's already done 2 years and 4 months. So I just don't want to promise him he'll be released today. He won't be released today. I don't know that it'll be tomorrow because of your medical situation. It may take a little bit longer, but my math is you ought to be getting out in the next couple of days, which is why he needs to then report to probation. One, he's already on probation, but two, he has 2 new probated sentences.
Correct. So just report within 48 hours. I see Officer Carter all the time, so I will update her. Plus, there'll be another order in for that. So just Mr. James, report within 48 hours of your release.
All right. You know where the probation office is?
Yes, sir.
On Memorial Drive near here?
Yes, sir.
Great. Missing that first date just means they're going to issue a warrant, and then what the heck? You're back in jail. So try to make it. All right. Thank you, Ms. Roberts. You parachuted into a complicated situation that only grew in complexity, and you have greatly assisted your client. I appreciate your services.
Thank you, Your Honor.
Thank you, Your Honor.
You bet.
Oh, Your Honor, that concludes my business. May I be excused?
You should leave now before another case finds you in here. Thank you. All right. Who's got something ready to go? Connor, Mitchell, Mr. Apt is on his way. He left Coweta County about 25 minutes ago. So he's working his way here. Ms. Feely, what do you have to say?
I'm sure the court was wondering why I was just chilling back there, but the deputy informed me I couldn't go back until they had more people. So,
Got it.
but now hopefully I'll be able to.
Okay. Well, why don't I do this then? If there's nothing ready right now? Yes, sir. Yeah. All right. So when your lawyer's here, we can do something with it. I'm gonna go take a break, and I will come back out when someone says we've got a plea. All right. Thank you. I've got potentially Mitchell, potentially Connor, definitely Santiago. I don't know about Castillo. Definitely Dawson. His lawyer's working his way this way, and
I'm sorry, I don't see Mr. Richardson. I know that when we spoke out in the hallway, he actually wanted to find out if we were going to be here tomorrow and if he could possibly come back for Mr. Steele tomorrow. He is not in here, so I'm not completely.
okay.
But that was what he said that he was going to ask for.
All right. Well, he would need, I appreciate you funneling it in for him, but his client's here and I don't want her to leave till we know what's going on. So I'm going to go back and I will come back out when we know more about things that might happen.
Court is in recess until all tracks.
Yeah, and everyone.
Yeah, if Mr. Arca gets here, we can roll. So you may want to see where he is.
Let me get out of here while I can.
Hey, whenever you're ready to go, I'm ready to roll. Oh, not even.
Yeah. I was literally up there. So who was calling the person just started, sitting there, this is the but we're good though. So that's it. 2 months.
Sorry, she ruined your day. If it makes you feel better, she doesn't.
It's absolutely fun. Absolutely.
Jasmine. Lauren came up here yesterday and blew up his plea as he was taking.
Oh, yeah.
She called me. So it's all right.
before. But which I.
That's the sheet.
Yes.
No, it's like, no.
Yeah, it's the whole thing is. Which I read back.
Speaking of on video, did you ever look at Raymond Richardson? Or was that kind of old?
Have you started looking at
Yeah,
this?
I just started looking at that
Listen,
stuff. I don't know how much more I can do.
it's,
I was like,
like, and I started, when baby started, it was, like, I, been kind of reading through stuff, but I didn't actually start doing tissue stuff
Same.
until, we needed to figure out if it was the same person. And then I finally, I wouldn't stop, you know, how much you. Because if not, I gotta stop.
he's on a trial calendar now, so I'm trying to get like,
Well, and she said,
get better. 'Cause
that's, yeah. But she said, look, it's, we can, at least, when I talk to her. And
was it, I've got two, so I'm assuming, something survey.
no, it was, I'll double back, it wasn't.
Gotcha.
And now it's two. I have, what are your thoughts on it? And I say that because I know you can't relax and question.
Yeah. I mean, I'm not thrilled about it either, but I mean.
And I really think this is honestly.
Right.
Of me to take that to her. And try to force her to that.
We just gotta cut a bunch of stuff out. I mean, and it just is really. Well, because we're all doing the same pre-20 whatever, yeah. Oh, get ready for this one, yeah. Yeah. Mhm. Yeah, I feel it. Yeah. It's good. I was like, stupid, it's not trying. It's killing me. It's like, yeah. My acres would be fine. Because I don't know if I actually told that. Mhm. I assume no one died, so, you know. Mhm. Mhm. Right. Mhm.
Yeah, so. No, it's
That means John left him in here, didn't even realize that he left him in here. Yeah. That's been in here for a while.
Since the last shot. And I talked to him yesterday.
Yes.
Yeah. No. No. See, they need it. They need it on the trial. Why he didn't think, where did I last go with it? I don't know. But I guess that's what happens when you are.
That's what happens.
She's evil.
She is. You see?
Okay, what y'all got going? How many y'all got left? Okay, you wanna go lunch now? Okay. So when is the other person? Racing.
Who hadn't been to lunch?
We in recess on council?
Yes, we are.
Until what time? The whole time?
They're just waiting to get please, so they're waiting on like 2 or 3 turns.
I just wanted to.
So y'all were leaving? For lunch? Okay, I'm gonna go to the other courtroom.
So B.
Not the 2B.
Boy, Erica's good. I just left them.
Okay, go, what about 2B? They still need somebody?
Yeah, we haven't been down there.
I'll go to 2B. I'll stay here and make sure they get lunch.
You gotta keep. Wait, go back
Oh, I'm sorry.
Grayson, you wanna go to lunch too?
Yeah, I mean, if y'all added people, I wouldn't.
Okay, you good? You go. Well, no, but she can. You gonna be here too? Yeah, both of y'all can go.
I was getting emotional, so I didn't want to be like.
All
the text.
You're not in it.
I just take it from there.
So how many y'all got left? Grace, how many you think we got left?
Oh,
Like a lot? You know, these things, I gotta keep some of y'all like that.
I wasn't even gonna fight with them, that's why I was like, oh, it's. No, they don't never do nothing. Only person talk about election, 99% of the time is catching, nobody else would do. Black every time. Catching on. You got a headache. If you go back and look at it, just catch that, I don't have to answer. That's the one. She being Barbara, that's the only one that really going to be. Yeah, but she said she don't need it. She didn't? Yeah.
Very just.
Okay, so position 4 can go down to his motion here. Oh, no, yeah.
Yeah, I was saying.
5, 4, 5, they can go, because they forgot.
But I need to know who's going to say it.
Oh.
You're not taking nobody.
Oh, anybody that don't have another room. So he can, Yes, yes. Extremely. Not close. Yeah, people in court. Yes, yes. It is. I put the set on the marriage because I think. So this will be your first one. But honestly, I don't think he's gonna use it like. He's gonna. In-house. And I will probably appreciate it.
Moments about it, the whole time.
So it's like three.
One of the defense attorneys is coming out here, so we just praying that it's not a lot of traffic.
I don't know, Cali there. I'm not even from here, it sounds far though.
I mean, it's just a big five, but it's not, it's not.
Not that
It's a corner.
It's not that.
Better cards. Yeah, hopefully.
Could you say we 26 in this courtroom? Would you call it out on radio to be 26 in this courtroom?
I did already.
Thank you.
Okay, yes, I did do that. Thank you. I have one. Do we have a person for that? I got one more. Madison. Deal. Yeah, and then I got a copy.
John trials, you know, the exempt from the training on Saturday, so.
It's my understanding, so. Yeah.
That's. Just one, or that might have already been.
One in February, it was, because it was last February. Yeah. I know it's wrong.
Thanks. Sort of.
It registered for summer conference. Yep, I didn't sign up for the whole thing, so I didn't help sign that registration was open. But I did sign up yesterday on wait list, and I kind of think.
It's already on the list.
Yes, and that's what was so surprising me, it's actually.
Yeah.
And I only remember because I registered right after I moved to the complex, and that was in April, so. But I did it, and, it took me. Who we sent the things, the payment.
Actually, we just basically replied to the list or something.
That's what I.
The reason I got in so early is Christian was waiting on the drop on his chest. That was the worst. That was like the biggest thing. I'm sorry,
Yeah, I should have gone all the well, you don't have the ability to do that, so never mind.
I should have at least said it around, that's not bad.
No, I completely forgot that.
I said we were doing on my back for the last.
What?
I'm still doing.
I was in the batch that got there, and then, they double paid us. Everything back. I was thinking, what is that? Hey, I think God made a mistake and paid me twice. And then they figured out, look at my account, they took part of it. Mine, take it.
I guess they couldn't do it.
Yeah, they couldn't, no, they had to do it for the whole.
How long did it take for them to put the action?
About 2 weeks.
That's why sometimes.
And that's what I said. Next time, if they ever have anything, I'll just write my check, bring it on over to you.
I will take it.
If you go, yeah, I will give you your money back, but I'm going to just write the check and bring it to you and say, no, you guys thank you, it's your.
Exactly. It's not do anything else.
Where today? And Picking my brother all day.
Yeah. Comfortability.
I wonder where's the sheet, the tracking sheet?
What was that? Is that yours or mine? Is that yours or mine?
I think.
Yeah. Okay, all right.
How we looking?
We're here.
Ready on anything?
We may be moments away on Connor.
Okay, just email me or whatever way is easier.
Yes, ma'am.
Okay, thank you.
Lead
Two
has
at
two
least,
cases, Renee Rockwell, she's on the Zoom, but I think she wanted to come talk to probation, so I'm not sure she's done that. And then two other attorneys, one on their way from Coweta, the other one, I think if they show up before the end of the calendar, just do it, but we haven't heard from.
Yeah, I'm just gonna try to see everybody. Looks like they did it right on the calendar. Okay, I'll let them handle it. Yeah, they did right.
He was sitting right there. But his attorney's on Zoom, and she said that she can finish via Zoom so long as the court allows.
So just make sure he gets.
Yeah, so long as I don't want to tell Ms. Nelson if.
I don't know.
So.
He's still here, they just sit down.
All right.
So you said you did come out, we see it from out.
Yeah, you remember.
Seven, we almost seven.
Yeah, yeah, I mean, if that's his hangup, it's
Yeah.
sort of,
I don't know if you're losing anything, frankly.
as he fully recovered.
Yeah. Okay. Okay.
Sorry. Oh, that's. Seven. This is the.
Understood.
No, well, I'm just checking.
Understood. Which one was always very kind of difficult to do all that, so it was.
That's what I mean, I honestly didn't anticipate the change because I knew I wasn't changing the registration status, so.
I thought that too, but then I went back through and calculated, I thought I said it like. This is the initial. Six, 7, 1.
So we're like a little over two.
So that's the same. I'm so sorry, I'm gonna just make sure it's not.
No.
Thank you so much.
I got you.
Excellent. My understanding is we're doing that, and we've got Ms. Rockwell right here. She is, and we will, whoops, she needs to start her video. Hey, Ms. Rockwell, when you are ready, fire up that video.
Hello, Judge.
Hey, how are you?
Not as good as you, but if you give me like 12 more seconds, you're going to see me in person.
Oh, okay.
I'm just outside. Here I am,
Cool.
and I got Ricky with me too. Do you need Ricky? Ricky?
I do. Yeah, he kind of ghosted us.
Judge, and I did speak with Madam Probation, and she said it's going to be up to you.
Ooh, I don't know what's up to me, but I always like it. So let's make sure all our necessary performers are here. Ms. Rivers is on. Fantastic. We've got Ms. Jackson, and now Ms. Tucson's official. It's not just a phone number. So Mr. Carter, come on up, please. This is position 9 on our calendar. You stand up at the podium right next to your lawyer. All right, Ms. Willingham, are you ready?
Yes, Your Honor.
Okay, position 9 is State versus Raymond Carter, 22 SC 180392. Mr. Carter is represented by Ms. Rockwell, who is here in court with her client. Mr. Carter, I understand you are prepared to enter a plea in your case. Is that correct?
Yes, sir.
Okay, for that to work, Ms. Willingham is going to put you under oath. Please answer all her questions truthfully and completely. And if you've got any questions of your own, let Ms. Rockwell or me know.
Could we get a copy of the indictment?
Yes, I can do that. But let's get going, and I will print it and get it to you.
All right, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name, your age, and your date of birth.
My name is Raymond Carter, born May 27th, 71. I'm 51 years old, 52.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
I graduated from high school.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes.
Yes, but we're about to get a copy that you assigned to.
All right.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
The negotiated plea in this case, as to count 1, 10 years to serve 1 year, commuted to time served with the balance prorated. As to count 2, serve 12 months, commuted to time served. The special conditions would require you to complete family violence intervention program, no contact with Tia Woodward, no drugs or alcohol, and subject to random screening, maintain employment, and no weapons. You are pleading guilty today to aggravated assault with a minimum of 1 year and a maximum of 20 years, and battery with a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything anywhere?
Yes.
Do you understand by pleading guilty today that your probation or parole will almost certainly be revoked?
That's what we were going to address you on. Yeah, this speak with my probation.
Council, can you all speak into the microphones?
Oh,
please?
yeah, their microphone's muted, so we'll fix that. If you just tap there, make that green. Good.
Green, Judge.
All right.
And Madam Prosecutor asked if he was on probation. It's my understanding that he is on probation either in 2019 or 2020. He entered a plea of 5 years probation. It is a Fulton County plea, Judge. He is being supervised out of DeKalb County, and I did speak with Madam Probation, and our global resolution is 10 to do 1, committed to the time he served. He's done 10 years plus 10 months, plus he's been on an ankle monitor for about a year.
You still have your ankle monitor?
Yeah, yeah.
All right.
And probation did look at everything and did say that it would be up to your honor, but she sounded like she was okay with it, and so is the state judge. That's our agreement.
So
with the
I
courts.
could, assuming I'm not increasing the negotiated resolution, handle a revocation and say, look, you've got a new conviction. I'm revoking credit for time served and continue on probation. So Mr. Carter avoids a warrant coming down the road because of this conviction.
Yes, sir.
Okay.
Exactly.
That's probably how we'll handle it, but let's let it flow. Do we
So
have,
that's
what's
the answer,
that
yes.
case number? Do you have the case for which he's on probation?
Madam Probation, would you put that on the record, please?
No
Would you like-
problem. 19 SC 172512.
Thank you.
No problem.
Okay, and I'll go back. Do you understand by pleading guilty today that your probation or parole will almost certainly be revoked?
Yes.
You heard me tell the court what the negotiation is in this case, which is 10
Judge
years to
gave me a
serve
bonus.
1 year commuted to time served. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 21 years?
Would you just read that to
Yeah,
him again?
repeat
One
that
second.
again.
Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 21 years?
Oh, yeah.
Do you understand, however, that if the court does not accept this negotiation, you have a right to withdraw your guilty plea today?
Yes.
I don't know that that's accurate.
I'm just gonna say.
We've passed that. So Mr. Carter's tendering a plea, and the sentence is the sentence. I don't have any reason right now to think I wouldn't go along with what's recommended, but you should understand, Mr. Carter, if for some reason I say I'm sentencing you to 20 years, you're getting 20 years. I don't think I'm gonna sentence you to 20 years, but you'll be rolling with whatever the outcome is, okay?
All right.
All right.
We answered that correctly, Judge, on the form, that
Good.
it is beyond final plea.
Correct.
Yes, Judge, and my apologies.
It's all right.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. For the special conditions, you are to have no contact with Tita Woodard, complete family violence intervention program, no drugs or alcohol, and be subject to random screenings, maintain employment, and have no weapons. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I have asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you in fact commit the offenses to which you are pleading guilty?
This is an offered plea,
Okay.
best interest plea.
Okay. Judge, and just for clarification, in your courtroom, do you still want me to read the facts? And I'm only asking because I know.
I do. No, I want you to share with me
Make sure.
what you think the evidence would be. And I'll talk with Mr. Carter about how an offered plea works.
If this case were to proceed to trial, the state would prove beyond a reasonable doubt that on November 25th, 2020, officers responded to 2850 Argyle Drive, Northwest Atlanta, Georgia, 30318. Upon arrival, officers spoke with Miss Woodard, who stated that her and the accused got into a verbal altercation in reference to an infidelity. The altercation then escalated when Mr. Carter hit her in the face multiple times. She was able to get away and knocked on the neighbor's door. Miss Woodard had a swollen face and bloody lip due to this altercation. Are you a United States citizen?
Yes, ma'am.
We shifted gears there. That was the facts, and now it's back to questions for you.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You have 4 years from the date the sentence is entered for the felony offense, and you have 12 months from the date the sentence is entered for, 12 months or 1 year from the date the sentence is entered for the misdemeanor offense. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes.
And he understands, Judge, that he's not allowed to possess firearms
He's
beyond
already there
probation.
because he's already a convicted
Yes.
felon. So that condition has not changed.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes.
Okay. Your Honor, the defendant has a criminal history of misdemeanor battery out of DeKalb from 1996, another simple battery out of DeKalb in 1996, a simple battery in 2006, and that is here in Fulton, possession of cocaine, 2007, that is here in Fulton, and possession of a firearm with aggravated assault charge from 2020, and that is the open probation case we discussed in 19 SC 172512. In this case, I recognize that the state, considering the defendant's criminal history, the state's offer is rather low. Your Honor, we have gotten in touch with our victim. However, she is not working with us to continue proceeding with this. And short of bringing her in by other means, this is what the state felt was best.
Okay. I worked with your predecessor on this and have signed a number of pieces of paper in an effort to get Ms. Woodard to interact with law enforcement in connection with this case. Thank you for sharing that. So my count was 3 or 4 misdemeanor convictions and then maybe 2 felony convictions. Okay. And one of the felony convictions I'm looking at now, that's the one that was with Judge Reeder that is still probation.
Correct.
Got it. Okay. Ms. Jackson, thank you for bearing with us all afternoon. Did you have anything in addition on your criminal history run for Mr. Carter?
No, Your Honor.
Okay, thank you. And Ms. Tucson, how much time remains on the 19 SC case?
He has 1 year, 7 months, and 9 days remaining on that 19 SC case.
Okay. Well, I want to get on the record that in December of 2020, probation filed a petition alleging Mr. Carter had violated his probation in that 19 SC case for this conduct. And on October 4th of 2021, I revoked Mr. Carter in the 19 SC case for this conduct. It just hadn't been indicted yet. So when it was a CP number, it resulted in a probation warrant and a revocation hearing. And there'd be double jeopardy if we revoked again. So let's see specifically what the revocation.
So that one's been handled then, basically. it was already revoked for.
Yes, ma'am. And an order that I entered, as I said, October 4th, 2021 is in the docket in that 19 SC case, and it was a 6-month revocation. And then reinstated the balance. So we've addressed that, and there is not any liability on that side. Okay, Ms. Rockwell, what do you want to add?
Just for the record, Judge, I'm happy to represent Mr. Carter. He's told you he's 51 years of age. He was born in Atlanta, attended Crim High. He graduated in 1990. He is not married, but does have 2 sons, 2 daughters, 4 what he calls grand girls, and then 1 great grand girl.
Pretty good for a 51-year-old.
He is gainfully employed. He's got the best job he's ever had. He makes $21 an hour. He works for the Bailey Street Bakery. He's a machine operator, and he loves his job. He has been friendly with Miss Tita Woodard for about 10 years. Through that relationship, he has also become a grandfather to a young man named Legend Woodard, Legend, Legend Woodard. That's Miss Tita Woodard's grandson, who considers him a grandfather. And he is 8 years old, and he's a wonderful young man. And he's also a young man that is very close to Mr. Carter, besides the fact that Mr. Carter is just crazy about him. I can tell you that Tita Woodard has moved on. They've been looking for her in Rex, Georgia. They could never find her in Rex, Georgia. And because of that, they asked for a material witness warrant. My understanding is that she is living now in Florida. She too has moved on, but they are still friendly because of the past relationship. And she told me, she said, I'm through with that case. She also told me that, and what I think is that if this case would go to trial, you would see that there was a whole lot of alcohol involved on her part. This happened next door to the neighbor's house where Miss Wood was trying to get help and get assistance. Mr. Carter, a little bit about him so you'll know about him. Mr. Carter had a crack problem for 21 years or
20 years.
20 years. In 2009, he went to rehab and has been clean ever since. Unfortunately, she has not. There was an argument over some infidelity. He tried to leave the situation. When he tried to leave, she tried to jump on his car and stop his car from driving off. He rolled down the window and pushed her off of the car. He didn't choke her. He didn't hit her. He didn't. She hurt herself. You'll see in the videos that she goes up to the neighbor's door and she's knocking on the neighbor's door. She leaves for a little while. She comes back and she doesn't even have her shirt on. It's whatever happened. A better thing for her to do would have been to talk with the state, and she was not even speaking with the state. She spoke with me and just tell them exactly what happened. She thought she could just not go in and this goes away. What was also happened concurrently with this is that Mr. Carter was a victim of another case, a case at her hands against her in Clayton County. She went to court regularly for that. And
Isn't she was the defendant?
She was the defendant. He did not participate in that prosecution because he has a lot to lose. He does not want to lose that child that he's in love with.
Legend lives where?
In Macon.
Okay, so as I understand it, Ms. Woodard is in Florida. I've seen information documenting that. So she's not around, but Legend's mother or parents are around in Macon.
Yes.
And so your ability, Mr. Carter, to see Legend and be present in his life doesn't have anything to do with Tita Woodard. You don't see him through her.
But if I do, yeah, it'd be through her. But I can't call her son, and her son will bring him.
Okay.
he likes to coordinate through her, and he's trying to keep it good with that family. I forgot to tell you, he does also have custody of a 14-year-old grand girl that he has, because his mother too got that gene and landed up in jail.
Daughter.
I'm sorry. That
I got it.
her
I mean,
mother.
the mother of the kid for which you have
Right.
custody.
Yes.
Because of her drug addiction. So there's a lot for him to live for. The judge that gave him the bond asked him to do this course. He did it. He successfully completed an anger management course. He did that in July of 2022. He stayed in jail for a good little while because of that, the bond situation, the probation situation.
301 days.
Yeah, that's real time. That's some real time. And he has had no hiccups with his ankle monitor. So I told him today, if Your Honor was in agreement with it, he'd probably be able to drive straight up to the A&A All County Monitoring and get that ankle monitor removed. So we would ask you to consider the fact I've got his pay stubs right here. He's making great money. They love him there. Looks like he's even applied for a car. He said, now I can buy me a car. He's got a relationship with a credit union. He's going to buy himself a car, and he's going to do wonderfully on probation, and he's going to stay sober. This didn't rock him. This jail time didn't rock him. He lost everything. I do want you to know about the case that he's on probation for right now.
The attempted murder.
Well, he was with his brother. They were living together, and they were, whatever happened, it was a get out of jail plea. And I tell people all the time, when you engage in those get out of jail pleas, you're fighting those cases the rest of your life, not just to get out of jail. So I would ask you to consider the amount of time he did in jail, the amount of time he's doing now on this ankle monitor, his job, his car loan he's about to get, the fact that he's important in a 14-year-old's life and in an 8-year-old's life and in everybody else's life. I would ask that you follow the recommendation of the state, accept the plea, Judge.
Okay. Mr. Carter, what do you do at this bakery?
I'm a machine operator.
Does that mean like you press buttons and donuts come out, or?
I make sure that the bread is cut right and just make sure the line is running right.
I bet it smells good where you work.
Yeah.
I met guys who work at chicken processing plants.
Yeah.
Those do not smell good.
Mhm.
Bakery, I bet that smells good.
Yes.
All right. Do you have any questions about anything we've discussed?
No, sir.
Okay. Mr. Carter, an offered plea is when a defendant says through his lawyer, look, it didn't happen the way the state says it happens, but I want to plead this out. I want to move on. I'm going to take this offer rather than run risk of going to trial. And maybe there are photos of Ms. Woodard and a police officer says her face was pretty banged up. And a jury decides, gosh, you already have some simple battery convictions. Maybe you did beat her up. And then you're looking at something more serious. So I can accept an offered plea. You need to understand it's still a conviction. It's not a NOLO. It's not something that's invisible on your criminal history. You understand that?
Yes.
Okay. Well, I find there's a factual basis, meaning a jury could find that you did what you're charged with. I don't know that they would, but they could. And so you're entering a plea. I also find your plea is knowing and voluntary. Voluntary means no one's forcing you to do this.
Smells
and no-
not up. But they admitted us. That's
Sorry about that. Tawfiq, you need to keep it quiet. Do you have any questions about anything we've discussed?
No, sir.
I'm sentencing you under the Probation Options Management Act, which means that while you're on probation, which you will be for a little while, if you have a minor violation, you miss a meeting or something, that goes to probation and you and they will sort it out. But if it is major, you get arrested again, anything about you putting your hands on someone the wrong way, that comes back to me and we'll work through the consequences. Have you all signed the indictment? Great. So Mr. Carter, this is your signature on the indictment indicating your offered plea?
Yes.
And you signed it as well, Ms. Rockwell?
I did, Judge.
All right. And I think I see Ms. Willingham's, and I will date it the 22nd. March 23. Excellent. All right. Mr. Carter, I'm going to sentence you on count 1 to 6 years to serve 9 months with the balance on probation. You've already served over 9 months, so you're not going back into custody. Count 2, you will serve, make sure it doesn't merge. Nope. Is a sentence of 9 months to serve. It'll run concurrently with count 1. So it's overall a sentence of 6 years to serve 9 months with the balance on probation. It's a little less probation than Ms. Willingham asked for. I'm not a fan of real long probation sentences unless, 1, there's a lot of restitution to be paid. It's not your case. Or 2, we've got a younger defendant and I need some room to work with that younger defendant. You've either figured things out or you haven't, and I'm going to know in 6 months or so whether you sorted things out with Ms. Woodard or not. I'll be happy to revoke a whole lot of it, and there goes the job and maybe the car and your time with Legend if you are getting mixed up in relationships where you're feeling the need to put hands on people in a way they did not invite. I am going to require that you complete a family violence intervention program. That's not just one class, it's actually a series of classes. That'll be a special condition of your probation. And I'm just going to draw a bright line. I want you to be with Legend. I just don't want Ms. Woodard, Tita Woodard, to be a trigger for anything because she's working through her own struggles and she uses Legend as a tool against you. And so it's going to be a special condition of your probation that you may have no contact with Tita Woodard. Don't call her, don't write her, nothing. If Ms. Woodard wants to change that, she needs to contact the prosecutor to say, I'm all right with Raymond Carter calling me so he can spend time with my grandson. But until she does that, you need to leave her alone. And I heard you say, actually, you can go through Legend's dad to spend time with Legend. And that's how you're going to have to do it. It sounds like Ms. Woodard has moved on, but people can be fickle. And you may just send her a text saying, hey, baby, just thinking about you. She goes to the prosecution with that. You violated a special condition. There goes a year, 2 years. So you just need, I understand you're on friendly terms now. You need to be on no terms now. Does that make sense?
Yeah, that makes sense.
I don't mean that as punishment. Your punishment was 301 days in jail. It is in your best interest to have her go one way and you go another way. All right. Ms. Willingham, any other conditions you wanted to see in the case?
No other conditions, Your Honor, but I would ask, I missed, for count 2, did you say 9 months?
9 months to serve, and that'll run concurrently with count 1.
And be commuted to the time he served.
Nope, he served more than 9 months.
I see, okay.
So I'm not a big reduced to time served person. And he did 301 days. I was going to say 10 months, but that's awfully close. I don't want it to be close. But 9 months is well under 301 days. So you served your time. Sure, it was unpleasant. Let's not do things that present that opportunity again. Okay?
Yes, sir.
All right. Ms. Tucson, can you please give you're already on probation.
Yes.
You got a probation officer.
Yes.
Okay. What do you need to tell him, Ms. Tucson?
I need to get an updated phone number and then I will reach out to his officer and let his officer know that he just took the plea in this case. And then he'll need to report because it usually takes about a week to get the information uploaded to them. But he's already on probation in the Stone Mountain office. You know where that is in Conyers?
Yes, yes.
Okay, so then just make sure you report that. And what is a good number for you so that way I could give it to your officer?
What's a good number for you? Tell me.
678-914-2319.
678-914-2319.
Yes.
Okay, and this is your direct cell phone?
Yes.
Okay, just make sure, I'm just to give you a date, make sure you report no later than April 3rd. However, you're probably going to hear from your officer prior to that, okay?
Yes, I got a number. I'll call him.
Okay.
Is that going to be in the Stone Mountain office, Madam Probation?
Yes, it won't be transferred back to Atlanta since he does not live in Fulton County.
Judge, could we handle the 19 SC 1725?
Yeah, there already was a revocation. There's nothing to do with it. That was that October date that I gave you. He's already been revoked, 6 months for that. So he's good to go.
Thank
All
you,
right.
Judge. May we be excused?
You may. Thank
And
you.
Just in the interest of justice, are those,
Justice.
those warrants pending against Ms. Woodard, could those be withdrawn, or does this case effectively close those out?
It should. That's a good question for Ms. Willingham. I signed what I was presented with because they were appropriate at the time. I don't know how that works.
Judge, I actually have not had to have any warrants issued against my victims in the past. But I would assume that I just need to ask to withdraw them. But I
don't
will,
know.
in the event that there's something different, I will make sure that I notify.
Yeah, just research it.
Ms. Roberts.
Yeah, and I'll sign whatever I need to sign. I don't know if they are automatically extinguished. Mr. Whitenauer may know. He's the one who swore them out. So,
I will make sure.
okay.
Thank you,
Fantastic.
Judge. May we be excused?
You may.
Thank you.
So what can we do next? Oh, hey. Okay. Yeah, let me ask, Ms. Feely, have you had a chance to confer with Mr. Connor and Mr. Mitchell?
I
Because the
have,
deputies will want to make sure folks have been seen, and we need to take custody, please, first because of the transportation situation.
so I would like for Connor and Mitchell to stay. Connor is a definite plea. Mitchell, we're still, I'm still trying to get what we need.
Make
to
it
do.
happen?
Yeah.
Hold on one second. Can we do the Connor plea now? Okay,
court-
let's do
the
that.
court's called.
Mr. Apt, we will certainly take Mr. Santiago Cano's plea. I assume you can, we got to, there's pressure to get folks in custody, but we'll handle that.
I appreciate the court's patience.
No problem. We've been handling other things.
Apologize for my tardiness. I was in Tweedy County all day, but I'm glad to be here and
Good.
I'm here at the court's level.
Excellent. What do you, oh, no, yeah, next time, I didn't know they filled one of these out. I'll get the signatures verified on the record, but that's fine. Do we know what's happening with the co-defendant? Mr. Richardson was here, then he wasn't here.
My brief conversation with Mr. Richardson is he's waiting to see what happens with Mr. Khan.
Oh, all right. Get in line, I guess. We're going to bring Mr. Connor out as soon as you guys are ready to do that. Thank you. Is this your one case in here?
It is my one case.
Okay.
Judge.
Is this negotiated? No? Ms. Feely's like, wait, what?
I seem to remember that it is at the very least a joint recommendation, and I don't think that we had a final plea date before the case.
Oh, we've had probably 10 final plea days. We're past that.
I think what.
This is,
Medical thing happened.
Mr. Connor rolls with what I give him, but this will be a joint recommendation, which means it's negotiated. It just, those don't ever bind the judge anyway. Okay, well, let's get on the record. This is position 2 on our trial calendar, 18 SC 162181, State versus John Connor. Mr. Connor is here in court with his lawyer, Ms. Feely. Mr. Shapiro is here in court on behalf of the state. Mr. Connor, how are you feeling? I should target that. You may be nervous, you may be anxious, but you've also been unwell. Are you better, or at least feeling better on the medical front?
Yeah.
Good.
There's still a few side effects, but, and all in all, everything's looking good.
Okay. You are welcome to take your mask off. During these proceedings, you're not required to. It'll make it easier for the court reporter to hear you. All right, Mr. Connor, Mr. Shapiro is going to put you under oath in just a moment. And once you're under oath, you need to answer his questions and mine truthfully and completely. If you have any questions of your own, it's very important that you let Ms. Feely or me know so that one of us can do our best to answer your questions. Will you do that?
Yes.
All right, Mr. Shapiro.
All right, Mr. Connor, would you please raise your right hand, sir? Do you swear or affirm that any statements or testimony that you shall give in this matter now before the court will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Connor. You can go ahead and lower your hand. Would you please start by stating your true and correct legal name for the record?
John Robert Connor.
And are you at this time taking or under the influence of any medications, drugs, or alcohol?
just prescription.
Okay. Does that prescription medication affect your ability to understand these proceedings?
No.
Mr. Connor, how old are you?
52.
And how far did you go in school?
1 year of college.
Okay. Are you able to read and write and understand the English language, sir?
Yes.
Mr. Connor, do you understand that in this indictment, you were charged with the following offenses: 3 counts of incest, 3 counts of rape, a single count of aggravated child molestation, 3 counts of aggravated sexual battery, 2 counts of child molestation, and 3 counts of sexual battery?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to those offenses?
Yes.
Do you understand that if you were to plead not guilty or were to remain silent and refuse to enter any plea at all, then the state would be required to prove these offenses against you at a jury trial?
Yes.
Mr. Connor, have you had enough time to speak with your attorney about all of the charges in this indictment?
Yes.
And do you need more time to discuss the case with your attorney?
No.
And are you satisfied with your attorney's services?
Yes.
And Ms. Feely, are we waiving a formal reading of the indictment for purposes of the plea?
Yes.
And are we waiving any defects in the indictment for purposes of the plea?
Yes.
Mr. Connie, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading guilty today?
Yes.
And do you understand that today you are entering a negotiated plea of guilty, which means that the state is going to recommend to the court the following sentence? The state is going to recommend that counts 1 through 10 of the indictment be dismissed. We'll be moving for a null pros. That for counts 11 and 12, which are the 2 counts of child molestation, the state is going to recommend that you be sentenced to 15 years to serve 7 in custody with the balance on probation, that you will receive credit for time you have served, and that you must register as a sex offender and follow all conditions of sex offender registry while on probation. Is that your understanding of the negotiated plea you're accepting today?
Yes.
And I'm sorry to state for the record, as to the remaining counts of 13 through 15, the state's going to recommend a dismissal of those counts as well. Is that your understanding of the negotiated plea you're accepting?
Yes.
Do you
I'm
understand
going
that?
to interject for one moment.
Yes, Judge.
It's important you understand, Mr. Connor, that your requirement to comply with the sex offender registry requirements could extend beyond your probation. So you're going to serve more time in custody. You'll probably get paroled, may not, but you could get paroled. It's a parolable offense. Then you'll be on probation for 8 years. After that magic 8th year, it's not the case necessarily that you are free from the requirements of the Sex Offender Registry Act. Just want to make sure you understand that, because what Mr. Shapiro said is, hey, as long as you're on probation, you have to comply. True, but you will probably have to comply, as in can't live next to a school, can't work in a daycare center, things like that, long after your probation is over. Do you understand that?
Yes.
Okay.
Thank you, Judge. Mr. Connor, do you understand that the court has the right to sentence you to the maximum possible sentence for these charges, which for the offenses of child molestation could be up to 20 years in custody?
Yes. Yes.
And do you understand that because there's multiple charges to which you're pleading guilty, that the court does have the right to sentence you consecutively for those charges, which means to run them one after the other?
Yes.
Thank you, Mr. Connor. Mr. Connor, do you understand that while on probation, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes.
And do you understand that while on probation, you must follow all the special conditions of your probation, including the conditions of sex offender registry?
Yes.
And do you understand that if you fail to follow the special conditions of your probation, then you could be subject to a revocation of your probation for the balance of your sentence?
Yes.
And do you understand that because you are pleading guilty to felony offenses, you may not receive, possess, or transport a firearm?
Yes.
And do you understand that doing so could result in new criminal charges for which you could face a sentence between 1 and 5 years?
Yes.
Mr. Connor, do you understand that because you're pleading guilty to a crime that involves conduct of a sexual nature involving a minor, you're pleading guilty to what's called a dangerous sexual offense as defined by state law, and you will be required to register as a sex offender?
Yes.
Mr. Connor, do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
And do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes.
And is it your decision to waive those rights, which means not to use them, and to enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
And is it your decision to enter a guilty plea because you are in fact guilty?
We had actually discussed him pleading under Alfred as well.
So, Mr. Connor, are you entering a guilty plea because you've decided that it's in your best interest to do so?
Yes.
And you are then asking to enter a guilty plea pursuant to North Carolina versus Alford. Is that correct?
Yes.
Do you understand that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
And Mr. Connor, in indictment number 18 SC 162181, how do you plead to count 11 child molestation?
Guilty.
And how do you plead to count 12 child molestation?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of this guilty plea or any other constitutional aspect of your guilty plea, you must do so by filing what's called a habeas corpus petition?
Yes.
And do you understand that because these are felony offenses, you would have only 4 years from today to file a habeas corpus petition?
Yes.
Thank you, Mr. Connor. Your Honor, that concludes the plea colloquy. As for the factual basis of this plea, this case arises from a March 27th, 2018 report to the Chattahoochee Hills Police Department. This was a delayed complaint of child molestation. The victim, Heather Connor, who is the defendant's biological daughter, reported that from the years 2008 through 2013, when she was between 11 and 16, her father, John Connor, had molested her. Officers interviewed Heather Connor at the Chattahoochee Hills Police Headquarters regarding the allegations of ongoing sexual abuse. As the court's aware, with multiple episodic, long-standing abuse, giving details of specific incidents can sometimes be difficult. However, Heather described in her interview with investigators at least 3 specific incidents, the first occurring between 2008 and 2009 when she was age 11. She stated that she was home alone with the defendant when he began touching her under her bra and her shirt. He then began running his hand over her breasts as well as penetrating her vagina with his fingers. Heather recalled a second incident between 2011 and 2012 when she was 14 or 15 years old. She stated that the defendant provided her with alcohol, making her feel dizzy and foggy. He then took her clothes off and penetrated her vagina with his penis. She passed out during the incident, but awoke naked on the living room floor. And finally, a third incident occurring in 2013 when she was 16 years old. She stated that the defendant removed her clothes and had sexual intercourse with her. In all, Heather was able to recall 4 distinct incidents of actual vaginal penetration by her father. However, there were many other instances of inappropriate sexual behavior, including digital penetration, fondling, rubbing of her vagina and her breasts. The way Heather described it to officers was this was frequent and often occurring sexual abuse that lasted for years. Judge, I'll state for the record that the state has discussed the negotiated resolution with the victim. This was a case of an extremely delayed outcry. And now, given the fact that the case has been in judicial hold for some time while the defendant was receiving treatment, the state is striving for a resolution for this victim. And so she has been notified of the state's recommendation, is in agreement with the state's recommendation in this case.
How old is she now? Well, is she an adult now? In other words, you're talking to her directly rather than through her mother or some other guardian?
That's correct, Judge. Without placing her full birth date on the record, I'll just state that she is an adult now. Yes.
Okay. There was a Douglas County case against Mr. Connor. Does it involve the same victim and essentially the same conduct, but in Douglas County rather than in Fulton County? I mean, Chattahoochee Hills is up near Douglas County. And so I'm curious if it's a different victim, different time frame, or it really would have been if it was a federal case, all one case, because they'd have jurisdiction in both counties.
That's correct, Judge. So this is all the same victim. And one of the issues that we have is the jurisdictional issue of, as I said, with multi-episodic abuse, recalling the specific dates and times can be difficult. However, at the time the outcry, the victim was residing on Cochrane Mill Road in Fulton County. And so, yes, there is the case in another county, given its conduct that occurred in that county. However, it is the same victim as in our case.
Got it. So it's an extension of the same illegal, improper relationship.
Conduct. Yeah,
Got it.
correct, Judge.
Okay. And has the victim received counseling? What state is she in terms of getting support for what's happened?
The victim has received counseling in the past.
Okay. The way you're structuring this resolution includes dismissing the far more serious counts that would carry mandatory minimums much higher than this outcome. Were there concerns about the strength of the state's proof, or just this is an old case and we'd rather not, and the victim would rather not be put through talking with 12 strangers about what happened?
So, Judge, I think in arriving at this resolution, those are both considerations that the state took into account. Again, with multi-episodic, years-long abuse, recalling specific dates, times can be very difficult, even if the victim is now an adult. In addition, again, this was a very delayed outcry. All of those factor into a jury's consideration of what would ultimately be testimonial evidence from the victim, and the inability to recall specific dates and times is unfortunately sometimes held against victims in cases such as these in terms of their credibility. And so, given the age of the case, generally, given the delay in the outcry, and again, given just the interest in some kind of resolution to allow this victim to move on, the state has made the recommendation that it's made.
Okay. Ms. Jackson, what can you share with me about Mr. Connor's criminal history, if any?
The defendant just has 2 cycles. The last arrest was November the 3rd, 2018 in Douglas County. For a charge that's similar to what he's being charged with. CWAC. It was null pros, August the 30th, 2021. Nothing in addition, Your Honor.
Thank you. Ms. Feely.
Thank you, Your Honor. As the court can probably tell by the discussion so far, this is not something that we just came up with on the fly. This has been ongoing discussions between Mr. Shapiro and I. As you heard, Mr. Connor has no record except for these 2 cycles where he booked in Douglas and in Fulton. So he's been alive 52 years without any problems. He actually was a school bus driver for years. He also has electrical training. This outcry was made when the complaining witness was already an adult. He also has another adult daughter and a wife. But this has just been heartbreaking for this family and for this whole thing. One of the considerations for Mr. Connor is how difficult a trial would be on everybody, including her, including him. And so we've kind of kept that in mind to try to resolve this short of trial. He's been in, I need to put the dates on the record of how long he's been in, but we are just urging the court to accept what we've worked very hard to present to the court as a resolution for this very old case.
Am I remembering correctly that while there may not be arrests, there are other allegations floating around? Because I think we had a 413 or 414 hearing, but it was I hope I'm not getting the wrong defendant. It was an alleged male victim rather than, it was a boy rather than a girl.
That was before my time assigned to the case, Judge, but that is correct. And those were the 413, 414 victims. Both of them, there were actually 2 in this specific incident, but those were much older incidents. And again, just unrelated to this specific period of time in which this conduct is alleged. But that is correct that there was also a male victim.
Okay. And has Mr. Connor gotten out since November of 2018? You know, our jail screen says 500 days or something, which is a huge number, but a lot less than if Mr. Connor has been in continuous custody since the arrest date that we heard Ms. Jackson mention. Because for a long time, he was in Douglas County and we had to borrow him to see what was going on. This was, Mr. Shapiro was in law school then, but it was a long time ago.
So he has actually been in continuous custody since April 19th of 2018. That's when he booked into Fulton, and then he was taken to Douglas, I believe, later on in 2018.
Got it.
And Judge, just for the court's edification here, it's the original arrest date is April 19th, 2018. He was then released on March 3rd of 2020, excuse me, not released, but transferred. So that's 686 days in custody. Then was returned from August 9th of 2021 through August 20th of 2021. So an additional 12 days in custody. And then finally, the 568 that Your Honor mentioned is just the current term.
Okay, well, I think his sentence should reflect that he has been in custody almost 5 years. And so if we can just verify, I mean, I don't know what Ms. Nelson's going to need to put on the booking, the final disposition, but I want to make clear for the record that the sentence that I impose ought to reflect the sentence I impose is the sentence I impose. Mr. Connor should get credit for having been in continuous custody in relation to this collection of offenses against his daughter from the 19th of April, 2018. So he's fast approaching 5 years. So if I imposed a 5-year sentence, you're almost done. It's not going to be a 5-year sentence, but you'd be almost done. And so Ms. Nelson will do her best to reflect that in the final disposition. This transcript of the plea will be what people can turn to if the Department of Corrections says, wait a minute, you only get time for Fulton and only the most recent stint in Fulton of the 500 days or whatever it is. Mr. Connor should get credit for the nearly 5 years he's been in. And if for some reason that is denied, then I will need to resentence Mr. Connor to back out a few years so that his sentence will be as long as I intend it to be, and I intend it to include the 5 he's already served. Back to you. Or had you finished?
The only other thing is I spoke with his wife, and I think that's weighing heavily on his mind too, as while there are very clear ramifications of this plea, his family's goal is to get him closure on this case and hopefully get him home at some point sooner rather than later than a trial would have.
I may have missed it. Was it a condition of probation that Mr. Connor not have contact with Heather? She's an adult now, so she can decide whether she wants to amend that. But going in, was it no contact, or I didn't write it down?
Judge, you probably missed it because I neglected to say it, but yes, we'd ask for no contact with the victim.
And is her last name still Connor?
Yes.
Okay. Does she live on her own, or does she live with her mother, which would be complicated for Mr. Connor when he gets out?
Judge, more recently, I'm not familiar with the specifics of her living situation.
I know
I'm sorry, go ahead.
Speaking with Kim Connor today, she does not live there and hasn't for some time. The other adult daughter does live there and wishes to have contact with Mr. Connor.
Okay. And Heather Connor I'm happy to change the sentence if she reaches out to the district attorney's office and says, I'm all right with contact with John Connor. Okay. Mr. Connor, anything you want to add?
I was just going to say I have no intentions of trying to contact her.
Okay. That's a good plan. Mr. Connor, we've already talked about the registry. You understand you'll be required to register as a sex offender as a result of this plea, and those requirements will likely extend beyond the end of your sentence in this case. Although there are ways you can petition a judge to relieve you from those requirements after you've completed your sentence, and there may be some other boxes you need to check. I'm not your lawyer, but I do know that there are ways to get removed from the registry after a sentence is complete. You understand that? Okay. Mr. Connor, I find there's a factual basis for your plea. I understand this is an offered plea, which says to me, you don't agree with some or maybe all of the allegations that have been brought against you, but you've decided that it's in your best interest to enter a plea to the 2 counts of child molestation, all other counts being dismissed. Is that correct?
Yes.
Understand this will still show up as a conviction in your criminal history. So if you're looking for a job, when you get out and they run, it'll say felony. It may say child molestation. I don't know how those queries work, but it certainly will reflect as a felony conviction. You understand?
Yes.
Okay. I find there's a factual basis for your plea and that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea, but after consulting with your lawyer and maybe others, you've decided this is how you want to move forward. Is that correct?
Yes.
And a knowing plea means that you've understood everything that's been discussed thus far. Do you have any questions about anything anyone has said up to this point?
No, sir.
I'm sentencing you pursuant to the Probation Options Management Act, which means simply that while you're on probation, if you have a minor or technical violation, you and probation will solve that. If it is a more significant violation, get arrested again, or if there's evidence that you were trying to contact Heather Connor, that comes back to me and I'll deal with what ought to happen. Okay?
Okay.
Mr. Connor, do you authorize my staff to sign the indictment indicating your offered plea to those 2 counts?
Yes.
Ms. Feely
Yes, Your Honor.
and Mr. Shapiro?
Thanks, Judge.
All right. Mr. Connor, you have been very well represented, really by a number of lawyers, but Ms. Feely has brought this to a close as your advocate. You should be grateful for her efforts. I appreciate the state's work on this as well. When I first bumped into the case, the offer was 1 million years to serve and we'll see you after you're dead. And the state's entitled to make that offer and it reflects the gravity of the initial allegations. And we've moved from that as both sides realize there may need to be another way to approach it. That doesn't change how seriously I view this. And I appreciate Mr. Shapiro's observation that he is not in any way saying he doesn't think any of this happened, just that it's complicated to convince a jury when it's not a little kid sitting there anymore, but it's a grown-up who says, I don't remember, I can't be sure. I don't even know if that was in Douglas County or Fulton County. I don't care where it happened. These are real serious allegations. And insofar as they have scarred your daughter, they are permanent scars that she will be carrying with her as she moves through life. And that is unfortunate and not reversible. Mr. Connor, on count 11, I am sentencing you to 15 years to serve 9 with the balance on probation. And count 12, I'm sentencing you to 15 years to serve 9, also with a balance on probation. They'll run concurrently with each other. That's a little bit more than what was negotiated because I think there needs to be a little more time served. You are eligible for parole and you may get out next month because you've already served more than half your sentence. I don't know how that's going to play out, but I think I would be remiss if I imposed a sentence where you could be released too soon. And I don't know that the 5-ish years that you've served is enough. And so I'm extending it a little bit. It doesn't affect your eligibility for parole. It shrinks the period of time you'll be on probation, but you will be on probation now for 6 years and maybe parole for a longer period. But I think that more accurately reflects my understanding of the facts and circumstances of the case and the information I've received during the course of the prosecution of this case. Anything, and it will be a special condition of your probation, Mr. Connor, that you have no contact with Heather Connor. Mr. Shapiro, anything else?
I don't believe so, Judge.
Ms. Feely, anything else?
No, Your Honor.
And I'll repeat, but I've said it several times. It is my intention that Mr. Connor get credit for time served from April 19th, 2018.
Thank you.
Okay. Thank you, everyone. Mr. Richardson, I've been told that you and Ms. Castillo are going to wait to see what happens with Mr. Santiago, which I'm happy to do next. I know it's getting late, but we need to take these things. Do you have a conflict?
Tomorrow morning?
No, I have a conflict tomorrow morning. I am staying, and we have, I think, 1 inmate left. We got to process that. But my proposal was that we turn to Mr. Santiago now and take that plea. I know that's not your client, but hopefully people are right outside. If you're done, you can scram.
Thank you, Judge.
Sure.
That's Mr. Absconder.
Yeah.
We're kind of waiting to see what happened with his.
That's what was relayed to me. And so my invitation is wait and see, because we're going to do it right now. And then we can have a conversation about, we should take Ms. Castillo's plea right afterwards, if that's what's in the cards, or if there's a commitment that it's going to be a plea, maybe we figure out a way to do that before Monday.
Right, that's fine, Judge.
But why don't we?
Tomorrow Thursday?
Tomorrow is Thursday.
It's Thursday. Does court have any time that you'll have criminal cases?
I'll look, but you would be a walk-in, so it doesn't matter what I'm doing. If I've got a window, we can do it. We don't need to have a criminal calendar. But why don't we see how Mr. Santiago's plea goes, because it's going to happen right now. And then you and Ms. Castillo and Ms. Willingham and I can talk. Does that work?
Well, she took one of her, she had to pick one of her children up from school.
Okay.
So I should tell her whether to come back or ask her to come in tomorrow morning.
One of you should stay.
I'll stay.
Good. So stay, and then we'll make a plan. It won't be tomorrow morning, at least first thing in the morning, because I have an out of office obligation. I'm not trying to be vague. I just haven't seen my schedule.
I'll adjust my calendar to whatever the court says.
Right. We'll be able to do it in the afternoon. For sure. If it's going to, I mean, you may need to see what happens. You may hear something here. You may see something here and say, we'll see you on Monday trial. I don't know what it is Ms. Castillo is thinking is going to happen, but I'll let you process that for her. All right, Mr. Apt, we're ready when you and your client are ready. Come on up to the podium. Ms. Jackson, I don't mean to keep you after hours. We may have one more plea after this. You need to talk with Ms. Mitchell? I mean, with Ms. Willingham? Okay. But Ms. Jackson, I don't know how late you're able to stay. I'd like to fit in as many of these pleas as we can today. Tell me your schedule.
I was scheduled to get off at 4:30, Your Honor.
Uh-oh. Well, how about this? How about you help me with this one plea that we're doing now, and then I'll pay your overtime through David Summerlin, and you can sign off after this plea. Can we do one more with you?
Thank you, Your Honor.
Excellent. Ms. Tucson, how about you?
I'm okay. I'm good. I'll be here.
All right, we'll keep it for now. Let's get on the record with this case, which is number 8. Position 8 is 22 SC 180351, State versus Mr. Santiago Cano. He is represented by Mr. Apt, who is here. And we have Ms. Willingham as the prosecutor. We're going to put you under oath in just a moment. Once you're under oath, it's important, sir, that you answer truthfully and completely. You're welcome to keep the mask on as long as the court reporter can hear you, but you're welcome to remove masks in the courthouse now. That edict has been lifted. And it is, you need to make sure you ask Mr. Apt or me any questions you have if something comes up that is different from what you were expecting. I'm confident Mr. Apt has explained to you what's going to happen. Every once in a while, there's a surprise. And if something surprises you, you should tell him or me so we can talk to you about that. All right? Yes, Your Honor. Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Please state your name, your age, and your date of birth.
October, Javier Santiago Cano, October 20th, 1995.
Are you now under the influence of any medicine, drugs, or alcohol?
No.
How far did you go in school?
High school.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The state's recommendation in this case is that counts 1, 2, 5, 6, and 9 of this indictment would be null pros, and that you would be pleading guilty to count 3, aggravated assault, with 3 years probation. Count 7, burglary in the first degree with 3 years probation. And count 8, possession of a firearm during the commission of a felony with a 5-year suspended sentence, which would give a total of 7-year sentence with 5 of those years suspended.
So I do different math. If it's 3 years probation,
They're to run concurrent as to, wait.
okay, but 3 and 5 is 8.
8, you're right,
Okay,
Judge. It's
good.
late in the day, I'm sorry.
That's all right. I just want to make sure I was following.
Wait, did I? Oh, I see what I see.
It's 3 years probation followed by 5 years suspended. So it's a total of 8-year sentence.
Yes.
But 3 years of probation because 5 of it's suspended.
Correct.
Correct.
Right. I just had heard 7 and 5 and 3 was 8. That's all.
You're right, Judge. My
We all went to law
apologies.
school because we were not mathematicians.
That is correct. With that said, you would be pleading guilty today to aggravated assault, burglary first degree, and possession of a firearm during the commission of a felony. Do you understand you are not required to plead guilty to the charges unless the grand, oh, that's for accusation. That does not matter. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law to the charges that you will be pleading to?
Yes,
And
ma'am.
has your attorney gone over the minimum and maximum
Yes.
sentences in these charges?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Under the general conditions, you will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to have no contact with the victim, no contact with the co-defendant in this case, no drugs or alcohol, be subjected to random screenings, obtain your GED if you don't already have that, and no weapons. Do you understand that a violation of any of these conditions could lead to a revocation on your probation?
Yes, ma'am.
Are you entering a plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which cause you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I have asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Are you entering your plea of guilty pursuant? It is my understanding you're entering an alpha plea.
Yes, ma'am.
These questions will pertain to that. Are you entering your plea of guilty pursuant to North Carolina v. Alfred, meaning that you may not admit guilt to every element of the crime charged, but believe it's in your best interest to plead guilty today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of 2 ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. For felonies, you will have 4 years from the date the sentence is entered. Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, ma'am.
Your Honor, moving over to the factual basis. If this case were to proceed to trial, the state would prove beyond a reasonable doubt that on December 8th, 2020, officers responded to 1677 Dorsey Avenue in East Point, Georgia, Fulton County, in reference to a person shot. When officers arrived, there were 4 small holes in the door and the doorknob was on the ground in front of the door. Upon making contact with the victim, officers were informed that he was in his home sleeping when he heard a knock on his front door. As he approached the door, he heard a female voice say, "It's me, Jessica." He explained that right after he heard the voice, gunshots came through the door, striking him. The victim stated that he was able to make it to his bedroom floor when he yelled, "You shot me," before reaching for his cell phone to call his daughter, Guyana, to tell her to call the police because he had been shot. As the victim laid on the floor, he heard another knock at the door, and because of the time that had passed, assumed it was police. So he proceeded to open the door. Upon opening the door, he saw a white Hispanic male pointing a gun at him and his soon-to-be ex-wife, Jessica Castillo. The defendant, Jessica Castillo, well, I will not get as much into Jessica's part.
Okay.
The victim stated he was unable to get to the floor due to the gunshot wound. Therefore, the male subject, later identified by the victim using his Facebook username, East Tweety Reyes, as Javier Santiago Cano, held the gun to his head while Jessica stole his Michael Kors backpack and his jewelry before leaving the residence in an unknown vehicle. The victim further explained that Jessica and the male subject, Javier Santiago, returned to the residence a short time later and fired 2 more shots into the residence. Nothing further from the state.
And Mr. Castillo, he was hit where? You said he was shot.
I skipped that part. That was it. Hold on, let me go back, Donna. To tell me where his wounds were.
Chest.
Your Honor, if memory serves me correct, when I spoke with Mr. Castillo, I was actually the person that indicted this. Back when I indicted it, I believe he was shot in his stomach. I can pull the medical records to confirm, but that's my understanding.
Okay. I mean, whatever it was, he survived. It's not a murder charge. Okay. All right.
Shot in the gut.
And I guess, Your Honor, what I should add to the record, just to clarify why the state is proceeding in the way in which we are.
Because that question was coming.
Yes. Is that Mr. Castillo is now serving a 15-year sentence in federal custody, and for various reasons does not wish to work with the state. Miss Castillo is his ex-wife and the mother of his child, in addition to his concerns of what testifying could possibly mean for him when we return him to federal custody.
Testifying in his own case.
Yes.
Okay.
And he
Do we know why he's serving 15 years?
I do.
I was gonna say, I did not write that down. However, if defense counsel wants to offer what he's serving it for, I'm perfectly fine with it.
It's a federal drug charge, Your Honor.
Okay. All right.
And Your Honor, I'm sorry. And lastly, in my involvement in the case, both at the indictment level as well as now, the state has had difficulties in speaking with Mr. Castillo as he has been in custody the entire time. He initially was in Clayton County when I first spoke with him regarding some state level charges there. And subsequently, after the case was indicted, he then was sentenced to his federal case.
He graduated to the feds.
Yes,
Okay.
so we have been out to speak with him. He has been very adamant that he does not want to proceed forward. He pretty much told me that when I first talked to him, but for obvious reasons, we indicted it anyway because it's a shooting, so.
Okay. Thank you. All right, Ms. Jackson, tell me please what criminal history you have, if any, for Mr. Santiago Cano.
The defendant has 11 cycles. The defendant's last arrest was August the 30th, 2021 in Clayton County for simple battery, robbery, and misdemeanor terroristic threats act. There was no disposition for that arrest. The defendant did receive first offender treatment in 2013 in Clayton County for felony obstruction. There was no seal date, and he has misdemeanor convictions and sentences. There was one in 2016 for giving false information to an officer and driving without a valid license. And the defendant received a nolo contendory sentence in 2014 for theft by shoplifting. And that was the one in 2013 for driving without a valid license. Nothing in addition, Your Honor.
Thank you. Ms. Tucson, is Mr. Santiago Cano on probation anywhere?
No, Judge, he is not on probation.
Thank you. Mr. App.
Your Honor, as you may have heard, but I'll try not to repeat too much. Mr. Santiago Cano is 27 years old. He is a U.S. citizen. He works full-time, Your Honor, at the Marigold Recycling Center. He's had that job for 4 years. He's a supervisor there. So he's got a good job that he's stable employment he's had for a while. He is engaged to be married to Ms. Savannah Leggett. She is in the courtroom. Don't stand up. She's expecting.
I think he's going to be a dad too.
He is a dad many times over. So to start with, he has two stepchildren who he supports that live with them, who are 12 and 8. Ms. Leggett's other 2 kids, one of whom is here today. He has a biological child with Ms. Leggett, who is 1 year old. He has the one that's on the way. And then he has 3 biological kids that live with him and Ms. Leggett from a previous relationship. He is the sole parent, guardian for those 3 children who are biologically his children, who are 11, 8, and 7. Their mother just left. So he has
a lot.
6 plus 1 on the way that he supports. He's the breadwinner. He does have a GED that he got. I don't think he knows where the certificate is, but he tells me he's got a GED. We are asking for this case to be an Alford plea. With respect to Mr. Castillo, the person who got shot, 2 things. And you know, this was a tough decision for Mr. Cano to plead guilty even under Alford. But you know, as I am duty bound, explain to him, trial is risky. I don't own a crystal ball to tell you what's going to happen at trial. And you know, if you are convicted, the downside risk here is tremendous. It's life plus. I think 125 years would be the max. Life plus 125. So I have spoken to Mr. Castillo recently. We arranged to speak to him in federal custody, and I spoke to him at great length. And what his story is now, not his story at the time of the arrest, and I don't know what his story would be going forward, but in the present moment, Mr. Castillo's story is, at the time I spoke to the police, I was high on drugs because I'm a drug dealer. And I don't know what I told them. I probably gave them the wrong information because I don't remember who shot me. And I have no knowledge that it was Mr. Cano or my ex-wife, Ms. Castillo, who's his co-defendant. So given that information, you know, we decided to proceed with this plea. He also previously memorialized that in writing to a letter that he copied me on and sent to the district attorney's office, and basically in great detail said, look, at the time of this incident, I was high as a kite. I don't know what I told the police, but I have no knowledge that it was Mr. Santiago Cano or my ex-wife who did this. I may have told the cops that, but I was high on drugs. And as I sit here now in prison, I don't know who did it. So as a result, we're here asking the court humbly and respectfully to accept this negotiated plea under Alford. And that is what I have for the court.
All right. Sir, what do you do at Marigold Recycling?
I'll be watching the lines going, make sure all the lines running good, and on your honor. I mean, sorry about it.
Okay. Don't worry.
I'll be watching the lines, make sure all the product metal goes through the line, and make sure all the employees wearing their safety glasses and helmet. And then,
is it a sorting center so that you're moving plastic in one way and metal?
It's metal and aluminum.
Okay.
So metal's going to go to the front and aluminum's going to the back.
Okay. And you're just making sure the right stuff is going in the right direction?
Yes, Your Honor.
How long have you been there?
I've been there for 4 years.
Okay. Have you been promoted while you were there, or have you always been a supervisor?
Yes, Your Honor. I was a picker and picking line. Then they booted me up to supervisors watching the lines and make sure all the guys have their safety glasses.
Okay.
And vests. Make sure anything goes wrong, I'll tell the operator to stop and we fix the problem and everything.
Do you wear your safety glasses?
Yes, sir. I know I really do have a little issue in my eye right now because
something got in there.
Yeah, dust.
That's why you got to wear safety glasses. How many kids are you planning to have overall?
Not sure at the moment.
You know, you have some control over that.
Yes, sir.
Yeah. You think this is the last one or maybe more?
Maybe. I'm not 100% sure.
Okay, you must make a lot at Marigold Recycling. Well, sir, you understand that an offered plea, and now two people have talked to you about it, means you're saying, I don't agree with what the state said I did, but it's in my best interest to take this deal rather than go to trial. You understand that?
Yes, sir. Yes, Your Honor.
You also understand that it's going to show up as a conviction on your criminal history. So even though it's offered, that doesn't mean if someone's running your criminal history, they won't notice that you've got a conviction for aggravated assault, aggravated assault and burglary and the gun charge. Those will show up on your criminal history.
Yes, Your Honor.
Okay. Then we will go forward. I find there's a factual basis for the plea, meaning a jury could, if Mr. Victor Castillo came into court and said, you know what, I stand by what I said originally. I wrote those letters because I was scared, because I've been threatened, or whatever his story might be. A jury might say, yeah, he was scared, he got threatened, and we think he would know his ex-wife if she's at the door. So you could be found guilty, which means there's a factual basis. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this, and knowing means you don't have any questions about anything we've discussed so far. Is that correct?
Yes, Your Honor.
I'm sentencing you pursuant to the Probation Options Management Act, which means simply that while you're on probation, you, if you have a technical violation, something small, you and probation work through that. If it is more substantive, you get arrested again, or you're bugging Mr. Castillo, or you're really going to need to stay away from Ms. Castillo as well. That's what the state has asked for. So if you are spending time with either of them, that's the kind of thing that will get you more seriously revoked. Understand? Okay. Mr. Cano, I'm holding here something called the plea of guilty. You put your initials next to a million things. Your lawyer signed it. Is it your signature on page 4?
Yes, Your Honor.
And Mr. Apt, you signed it as well?
I did, Your Honor.
Great. Do you authorize my staff, Mr. Cano, to sign the indictment indicating your offered plea to counts 3, 7, and 8?
Yes, Your Honor.
Mr. Apt?
Yes, Your Honor.
And Ms. Willingham? Good, we'll do that. I am going to sentence you on, based on everything I've heard, on counts 3 and 7 to 3 years, and count 8 has to be 5 years. It has to be consecutive. So it's a total of an 8-year sentence. The first 3 years are probated. The last 5 years are suspended. Special condition of probation number 1. The only special condition of probation, since you have your GED, is no contact with either Victor Castillo or your co-defendant, Jessica Castillo.
Yes, Your Honor.
Any other conditions that you meant to ask for that I didn't write down?
Judge, I did ask for no drugs or alcohol.
Okay. So I'm going to let probation manage that. If you're drinking beer, you're drinking beer. If you're getting high, probation's going to figure that out, and they do drug screens anyway. So I'm not going to add anything extra. I think that's it. You understand better than anyone else. You got a lot riding on staying out of trouble. They got a whole basketball team full of kids and another one coming. And so if you're goofing around, running and gunning with Ms. Castillo and this and that, you get locked up for 6 months. Someone's not going to be real excited and may not be there when you get back. And she will find someone else who is reliable to help take care of those kids. But I think you can do it. If you've been working at this place for so long, you got promoted, you wear your safety glasses, everything will be all right. Thank you, Mr. Apt. Last thing, we need to cover probation reporting. Ms. Toussaint.
Thank you. Mr. Santiago, where do you live?
I live in 948 Cone Road, Forest Park, Georgia.
948?
Yes, ma'am. Cone, C-O-N-E, Road, Forest Park, Georgia.
30297.
And your phone number?
678-254-8275, ma'am.
678-254-8275?
Yes, ma'am.
And is that Clayton County?
Yes, ma'am.
All right. Do you know where Clayton County office is?
Family probation?
Correct.
Yes, ma'am.
Because I'm still gonna call you and send you reporting instructions, but their address just it's for Clayton County. I have to give that to you.
Yeah, I think it's Citizen Parkway.
It's Citizens Parkway, correct. So make sure you report to probation April, I think that's the 5th on that Wednesday, April 5th.
Yes, ma'am.
Any particular time?
Probation, I'm not sure for Clayton what their intake times are, but they do open up. So just at 8, so report at 9 o'clock and I'll put that on the paperwork.
Yes, ma'am.
April 5th at 9 a.m.
Yes, ma'am.
Is that all you need?
Yes, and failure to report will result in a warrant.
Right. That'd be a poor choice. Don't miss
Yes,
it.
Your Honor.
Thank you, everyone.
Thank you, Your Honor. It's good to see you.
Same.
I'm glad we both wore purple.
There you go. I got a purple shirt too.
Does Your Honor, do you know David Gevertz?
I've heard the name before, but I can't link it to.
He was my college roommate. I was best man at his wedding. He was best man at mine. But I think he was in your law school class. And I know your law school has a lot of students.
It does, but maybe that's why the name sounds familiar.
We all were the same. I was a 95 law school grad. And he was 95.
As was I. So we would have been in the same class. So that's why I recognize the name. Thank you. So let's get some updates. Mr. Dawson, any update from your lawyer? I don't want to keep you here any longer. We're going to have to do the plea on another day. It's not your fault that we're not doing it today. We just need to get Mr. Arca in court. Have you talked to him at all?
He's still in traffic.
Still in traffic. All right. Ms. Nelson, if you don't mind coming out here, I just want to talk through what we're doing with Mr. Dawson, who's been here all afternoon. Ms. Feely, you still need to talk to Mr. Mitchell?
I have spoken with him. I think we are good for today if it's.
As in, we're taking a plea today, or we're done and he's going to be thinking about things?
We're not able to get it done today.
Okay. Do we need to bring him back later this week, or is this one that I should add to the list of, well, we may be trying this?
Sounds like we're at an impasse, so just add it for try.
Okay. Ms. Willingham, do you have a preference when it comes to trying Mitchell versus Grant?
I would prefer Mitchell.
Okay. I hate dragging Ms. Grant down again and again, and her case is old also. It got re-indicted, but she's not in jail. And Mr. Mitchell now is, and he is not leaving jail until a jury says guilty or not guilty. So how about you, Ms. Feely?
I'm ready on both of them. I would like to point out, and there was some discussion with Mr. Whitenauer, because Mr. Mitchell was in the Coweta County Jail at the time the Bish warrant was issued. Unfortunately, the GCIC says July 12th, and his court date was July 11th, but I think he was already in the process of getting booked in. So I think that at some point needs to be addressed as well.
Well, if we end up not reaching his case on this calendar, then let's revisit that. If the bench warrant was erroneously issued because it was impossible for Mr. Mitchell to get here, then we'll work through it. That would lead to a bond revocation question of what was he doing in Coweta County Jail while he was on bond in this case. But we'd have both those conversations. But since Monday is the trial date, I don't think we need to worry about bond. It would only be if it's a mistrial or we don't reach the case. But as between Mitchell and Grant, you're neutral.
If it allows Ms. Grant not to come down from Rome, Georgia again, I could say Mitchell if it makes a difference, but I'm equally ready on both.
Okay. I don't know that it will allow her from coming down, because if Mr. Mitchell on Monday morning says, I've bridged that gap, or I'm willing to plead blind, you'll recommend your number, you'll recommend your number, then I wouldn't want us to have nothing. We have a couple other cases, and so I'll send that email out to everyone, hopefully today. But we don't need to keep Mr. Mitchell here anymore. We still have to work through Mr. Dawson's situation and Ms. Castillo. Ms. Castillo has left, I believe, but Mr. Richardson.
He stepped up, the other attorney.
Okay, so he'll be right back in, and we just need to talk schedule. So Mr. Dawson says, Mr. Arca says he's still stuck in traffic. It's 5. we need to let Mr. Dawson go, but we'll need to figure out when you and your lawyer can come back this week to do the plea. And what we'll do is figure out a time when he can for sure be here. That's your case, Ms.? You have all the cases on here. Okay.
I did have to go with the calendar.
Yeah.
But yes, I did speak with Mr. Arpa yesterday. I will be happy to follow back up with him, as well as I'm sure Mr. Jordan, because I know they are friends. And we will get to Ms. Nelson with something, but
Okay.
I'm here all week.
Good. No. And it could well be if you're gearing up for trial because you have both Grant and Mitchell that Mr. Jordan handles the plea. We need to get Mr. Dawson in here and his lawyer. So we'll work with Mr. Arca's schedule. Is he pretty good about reaching out to you, Mr. Dawson? Like he's got your number, he can call you? Yes. Okay, you should go. All right, thanks for your time today.
And Darius, we have one more on there.
Your Honor, may I be excused, please?
Yes, Ms. Jackson, I'm sorry. When we were done with that plea, I meant for you to be able to go. Thank you so much.
Thank you.
Yep.
Darius, what about Bruce? Darius Brooks. He was on the 10:30 calendar.
Oh, yeah. So thank you for flagging that. He's actually not a drug court guy. So he's going to be handled in non-complex.
Okay.
And that we should have told you guys that, but the lawyers told me like, he's not even a drug court person. So Brooks, yeah, well, it's a break from being at Rice Street.
We just didn't know what was his deal. So.
Yeah, no, thank you for asking and thank you for not sending him down until we talked about it. I forgot to close the loop with you all, but they explained to me, the lawyers, that he actually was in the Behind the Bars program, which starts with the canine cellmates. And then there's one on the outside, and that one, he blew up on that. And so he's back in, and his case is going to have to go back to non-complex, not to drug court.
And what about Copeland? Copeland said he didn't understand, and when I came back out, his lawyer was gone, so I couldn't bring his lawyer back.
Copeland didn't understand that he got revoked for 1 year? Okay, he's gonna remain confused then, but he doesn't need to come back out. I'm gonna sign the order. Good, it was pretty clear, 1 year. Uno, año. All right, Mr. Richardson, last man standing here. So you understand what happened in the Santiago Cano. What does that mean as you translate it into Ms. Castillo's life? Is it a plea, a trial? What's happening?
The state made their offer better in the interim, so I need to communicate that to her. I think I have Ms. Willingham's cell number, so we'll exchange numbers tonight. I will speak to her about the revelation, if you want to call it that here, let her know.
It was 5 years probation before, so it's now even less probation?
3 years probation now.
Okay.
Judge, just for the record, I will say that.
We're not on the record, but you can tell me.
You're right. But I did not produce it at the last minute just because, but Mr. Richardson had already told me that she was gonna be a trial. So once I reduced the co-defendants, they were pretty dead set on it was a trial. So I wasn't trying to just withhold it. I just wanted to make sure all parties were aware.
That's fine, and you don't need to justify how you do your things. I just you're gonna share the new offer, and hopefully that's something she's willing to roll with. But that would need to be rolled with this week. So
I have to be here from office.
I didn't hear what you said. We could tomorrow afternoon. Yeah, tomorrow afternoon is the time to do it.
What time? 1 o'clock, 2 o'clock?
We're doing lots of different things. I'll slot it in. I mean, once you guys are ready, we'll say, hey, this other thing, because it's all criminal stuff. And so it'll blend in.
You guys be back from lunch at 12:31?
Let's start at 1 o'clock.
Yeah, calendars start up at 1. So please be here at some point in the 1 to 5 p.m. window. All right, great. And hopefully we can get Mr. Arca here in that same window. So Mr. Jordan, what that leaves is, so we've got Mitchell and Grant and wait on it, Rhodes. That will definitely be on the list. Lewis is a plea?
No, Lewis.
Oh, Loomis.
Sorry.
Okay. Then we've got Lewis and Hurd. think Lewis will be a plea too, especially if we put it first. Thank you, Ms. Rivers. Thank you, Ms. Tucson. I'm gonna end the call. Alas, we can't squeeze any more pleas in today.
Okay, have a good night.
Bye.